and published in 2017. Madam Speaker, those who know anything about AML-CFT, this is a huge positive change. There's much more work to be done, but we have to pause to note the progress that Jamaica is making. Put another way, Madam Speaker, we are partially compliant with 13 recommendations, an improvement over being partially compliant with 21 versus 21 recommendations. So I'm putting it in another way. We are partially compliant with 13, whereas before we were partially compliant with 21 and non-compliant with 2. In fact, 21 might be higher. Now, Madam Speaker, it should be noted that Jamaica needs to be compliant or largely compliant with at least 32 out of 40 recommendations to come out of the follow-up process with CFATF. So we're still in CFATF's follow-up, and next year we'll have to report again, and hopefully we'll be able to apply for a re-rating. And if we can go from 27 to 32, then we'll be out of the CFATF process. Now, the standard setter, Madam Speaker, which is FATF, deems a rating of compliant or largely compliant as generally satisfying the requirements of the recommendation. A rating of partially compliant or non-compliant is considered insufficient to meet the standards. The results of the re-rating exercise are just set out in the following paragraphs. 3 recommendations were upgraded from partially compliant to compliant, i.e. there's no further to go. And that's recommendation 12 in respect of politically exposed persons, recommendation 21 in respect of tipping off and confidentiality, and recommendation 33 in reference to statistics, that is maintaining and providing adequate statistics on AML-CFT. 7 recommendations, Madam Speaker, went from partially compliant, which is unsatisfactory, all to largely compliant, which is in the satisfactory bucket. And those are recommendation 2 on national cooperation and coordination, recommendation 10 on customer due diligence, recommendation 11 on record keeping, recommendation 14 on money or value transfer services, recommendation 17 on the reliance on third parties, and recommendation 18 on internal controls and foreign branches and subsidiaries, as well as recommendation 19 on higher risk countries, measures towards higher risk countries. 1 recommendation, Madam Speaker, went from totally non-compliant all the way to largely compliant, and that was recommendation 6 in respect of targeted financial sanctions related to terrorism and terrorist financing, Madam Speaker, as a result of legislation that we passed here in this House. Madam, 1 recommendation was upgraded from non-compliant to partially compliant, recommendation 8 on non-profit organizations. Recommendation 5, terrorist financing offense, maintained its largely compliant rating, while 5 recommendations maintained their initial rating of partially compliant. The 1 recommendation that was downgraded, Madam Speaker, is a recommendation 15 on new technologies, which was downgraded from compliant to partially compliant because the conditions for meeting the standards were amended post-Jamaica's mutual evaluation to require that countries mitigate the emerging risks from virtual assets by ensuring that virtual asset providers are regulated. We are currently working on updating the legal framework to include the regulation of virtual asset providers. Since its mutual evaluation, Madam Speaker, Jamaica has pursued and implemented a number of initiatives to strengthen its AML-CFT PF framework and has passed several amendments to its suite of AML-CFT PF legislation, all of which we passed in this House with the cooperation of both sides. Based on these efforts, Madam Speaker, in November 2019, Jamaica applied to the CFATF, I said this earlier, CFATF for re-ratings of 90 of the 40 recommendations. The positive outcomes that I alluded to earlier, that we now have 27 of the recommendations being rated as fully compliant or largely compliant, within striking distance of the threshold of 32 that takes us out of the follow-up process with CFATF. These positive outcomes, Madam Speaker, are in large part due to the tremendous, and I'd like the Parliament to recognise, cooperation and collaboration among our public sector agencies, the men and women of our public sector agencies, of the National Anti-Money Laundering Committee chaired by the Bank of Jamaica. I'd like to specially recognise the invaluable work provided by the Ministry of National Security, by the Ministry of Foreign Affairs and Foreign Trade, by the Attorney General's Chambers, by the Director of Public Prosecutions, the Office of the Chief Parliamentary Counsel, the Financial Services Commission, the Financial Investigation Division, and again, the Bank of Jamaica, Madam Speaker. Please, if we could just recognise their contributions. Madam Speaker, the Government of Jamaica is committed to the strengthening of Jamaica's framework of AML-CFT through the continued development of a sustainable program designed to ensure that the adequacy of our AML-CFT and proliferation laws and supporting infrastructure effectively disrupt the benefits of the proceeds of crime and disrupt the financing of any financial crime. In so doing, we are on the road to achieving removal from CFATF's enhanced follow-up process. Jamaica is also working, Madam Speaker, on completing the actions, including in its action plan, agreed between the Government of Jamaica and the Financial Action Task Force, of which the legislation to regulate the microcredit sector on the agenda for today is a primary ingredient and the first of the timelines for 2021. To this end, Madam Speaker, it is anticipated that the initiatives described above to exit CFATF's follow-up process would also work towards the country successfully exiting the FATF, Financial Action Task Force process, as well as its grey list on time and on schedule, with the ones with the EU and the list of third-party territories, and generally to ensure that the global community views Jamaica as a country whose economy is not susceptible to the risks or to grave risks of money laundering, terrorist financing, or proliferation financing. Thank you, Madam Speaker.
Members, before you start, Mr. Member Robinson, because we know you are going to contribute fully to this, I just want to thank and to congratulate the Minister of Finance. He started at 2:41 and he closed at 2:53, and I'm delighted because this is the way the work of the Parliament looks. Thank you, Minister. And his presentation was, in fact, distributed to all of us as it ought to be. Thank you.
No, I don't need that. Minister, could you indicate to the Parliament the time frame to get to the 32 of the 40 and the specific actions that are required to accomplish to get to that the 32? So we are out of the follow-up phase.
Thank you for that question, Member. To get to the 32, there are 13 recommendations, and I was trying to pull it up to get the exact ones, but there are 32. There are 13 recommendations from FATF for which we are not yet either compliant or largely compliant, and we have to. 5 of those 13. We are going to need to be in a position where we are compliant or largely compliant. If you give me a second, I will pull up some of those that we are. So here's what we're going to need to do. We're going to need to pass the microcredit bill, which is on the agenda for today. That will move us up by 1 in respect of regulating of microfinance entities. The second, we have to put in place a framework. This is if we're to do all 13. Put in place a framework to regulate trusts and company service providers. 3, make regulations under the United Nations Security Council resolution framework to prevent proliferation of weapons of mass destruction. So we passed the laws, but now we have to enact the regulation. 4 would be the new regulations for new technologies, as I mentioned earlier, which is virtual asset providers. While we have had people talking about them, we don't have any virtual asset providers as yet domiciled and issuing virtual assets in Jamaica just yet. But before that happens, we need to promulgate regulations that ensure that virtual assets, when they're become available by Jamaican or by providers who are in Jamaica, are not used for proliferation or money laundering purposes. Number 5 is a big one, updating the Companies Act to rectify the existing deficiencies relating to ultimate beneficial ownership. And that's one that's on the FATF list as well, where the Companies Act is going to have to be amended to require companies to disclose, companies incorporated here, to disclose their ultimate beneficial shareholder, ultimate beneficial shareholders who own at least 20% or more. But more than that, there has to be dissuasive penalties to ensure that companies who don't file that information are subject to sanction. The next would be the completion of the National Risk Assessment, which is underway and being led by the Bank of Jamaica, and I'm very confident about that being done on time. And then very importantly, the implementation of risk-based supervision by the competent authorities to include all non-designated financial businesses. So that is making sure that we have the regulation in the proper regulation in the gaming sector, in the accounting sector, in the real estate sector, in the legal provision, which is an issue that's before the courts, and in other designated non-financial businesses. That's the list from which we need to have 5 wins to move out of the CFATF process.
And what is the time frame that you envision we will accomplish this by?
We want to be able, on our next application to CFATF, to go up from the 27. I can't say here that we'll go from 27 to 32 in that, because some of the things that we have left are, are difficult. Certainly the National Risk Assessment, Microcredit Bill, definitely we'll get those. I'm hoping we'll get the Companies Act amendment this year, as well as maybe the United Nations resolution. I would say I would give, within 2 years we should be able to do that. Hopefully before, but within 2 years on CFATF. Okay.
Minister, just one question. You said 2 years to get out of the follow-up process for CFATF. What about the grey list? What's the time frame for getting us off of that?
Right. That one is we have been dealing with CFATF for a long time, so we are more familiar with their procedures. FATF is a very new level of interaction. We have an action plan with FATF, and our sort of understanding is as long as we meet the commitment under that action plan, then we should be favorably considered. And we intend to meet the commitments under the action plan. The first commitment for 2021 under the action plan is to pass a bill to regulate the microcredit sector, which is before the Parliament today. FATF has a way, however, of wanting to ensure effective implementation. Okay? So, in other words, the evidence has to exist that the various provisions that we have signed up to not only have been passed or done, but it is effected in the particular country, which is why, though we may meet all the things in action plan, and our action plan takes us to the end of this year, Right? Our action plan doesn't go beyond 2021. It finishes in 2021. But as always, we've seen it before with Trinidad. The last FATF meeting I went to, people would go up and countries would go up and say, look, we've done all of this. And from their view of the statistics, and they look at statistics a lot, because they believe if an AML regime is in place, then by definition, things should be popping up, because you understand what I'm saying? Like they pop up in Australia and New Zealand and other countries, right? You have fines being levied and all the time. That is the evidence of an effective regime. So if you pass the laws and there are no sanctions, the authorities don't give fines when people breach, and so forth, then they would not deem it to be effective. And that is why it requires action more than just the government or the minister. And why I'm making the effort to try and put it on the national radar, that this requires a society to recognize the fundamental importance of this area, and for all of the private sector and public sector entities involved to take it seriously. And remember, a lot of the supervisory entities are not government entities. The entities that supervise the real estate sector and the accounting sector and so forth, and even the legal profession, they have government input, but they're largely private sector driven. Those entities have to show that the regime is effective, that the regime for supervising the real estate provision is effective. And if real estate firms do not have the right due diligence processes in place, that those firms are sanctioned. And the same in the accounting profession and so forth. So that's why you can't speak. We can speak to what the actions that the government has, but FATF looks beyond that, and they want to see effective implementation. And that's why it needs all of society, and why we need the media, we need everybody on board to help us to get to that place where we have an effective anti-money laundering regime in Jamaica. Virtual asset is an asset that does not that exists in it's not a it exists in what's the proper definition? In an example, let me give you examples of virtual asset. An example of virtual asset would be, Bitcoin, or these assets that are digital in nature. There's no physical manifestation of them. So even though you can have an electronic manifestation of a dollar, right, a dollar ultimately can be brought into physical existence. A virtual asset remains digital for all of its existence, and that is an emerging part of the financial landscape internationally. There are countries in the Caribbean that have virtual assets as a feature of their economies. I know Bermuda and Barbados, and Jamaica is definitely going to move in that direction at some point. But before we move with momentum, and we want to make sure the regulatory regime exists, because by the very definition of virtual assets, right, where you can't trace, right, by the definition of virtual assets, if they can be used for nefarious activities.
Minister Tufton. Curtis. For next week. No, well, if you can.
It's all over there. Yeah. Thank you very much, Madam Madam Speaker. Madam Speaker, today I will table the COVID-19 vaccine deployment and vaccination interim plan. And I would just like to do a brief statement to update the House and the country on the critical components of the plan. So, Madam Speaker, the Cabinet has approved a national COVID-19 deployment and vaccination interim plan as the strategy and authority on the deployment of COVID-19 vaccines in Jamaica. The plan outlines the overall strategies for the deployment, implementation, and monitoring of the COVID-19 vaccines in the country. The plan is developed in a way that ensures alignment and integration with the national COVID-19 response and Recovery Program. Madam Speaker, the question may be asked, why an interim plan rather than just a plan? The COVID-19 pandemic is a very dynamic and fluid situation with continuous learning and new information being brought forth to the clinical and epidemiological features of the virus and its transmission. Additionally, on the matter of the development of COVID-19 vaccines, there is still some uncertainty in this area, such as the type and quantity of vaccines which may become available to Jamaica. Accordingly, this plan is developed, Madam Speaker, based on information which is currently available and the assumptions the government is able to make based on these currently available information. There will be future updates, therefore, to the plan as new information becomes available. Madam Speaker, before going into the details of the national COVID-19 deployment and vaccine interim plan, I wish to remind the Honourable House on the vaccine development process and the status of the vaccines under development globally. Madam Speaker, in order to ensure that the new vaccines being developed to combat the COVID-19 virus are safe and effective, the vaccine development process, as prescribed by the WHO, involves the preclinical testing, where each vaccine under development must first undergo screening and evaluation to determine which antigen should be used to invoke an immune response. This preclinical phase is done without testing on humans. Phase 1, safety trials, where the scientists give the vaccine to a small number of people to test safety and dosage, as well as to confirm that it stimulates an immune response. Phase 2, extended trials, where scientists give the vaccine to hundreds of people, split into groups such as children, the elderly, and others, to see if the vaccine acts differently in them. These trials, Madam Speaker, further test the vaccine's safety and ability to generate an immune response. Then you have phase 3, which is the efficacy trials, where scientists give the vaccine to thousands of people and wait to see how many become infected, compared with the volunteers who receive a placebo. And then the approval phase, where regulators review, Madam Speaker, the complete trial results and plans for a vaccine's manufacturing and decide whether to give it full approval. A vaccine must be proven to be safe and effective across a broad population before it will be approved and introduced into a national immunization program. And that has been the approach that Jamaica has taken from time immemorial, and we are very accustomed to vaccination and based on our immunization program. The bar, Madam Speaker, for vaccine safety and efficacy is extremely high, recognizing that vaccines are given to people who are otherwise healthy and specifically free from the illness. It's a message that we're going to have to carry a lot going into the future, Madam Speaker, based on many of the distractions and the alternative views that are out there. Madam Speaker, as of January 15, 2021, there are 77 COVID-19 vaccines under development, with 8 being granted emergency use approval in 1 or more countries. The 8 vaccines which have been granted emergency use approval in at least 1 country are BioNTech, Pfizer, approved for emergency use in 48 countries, Moderna in 34 countries, Gamaleya, 4 countries, Oxford AstraZeneca, 5 countries, Serum Institute of India, Covishield, 1 country, Bharat Biotech, Covaxin in 1 country, Sinopharm, BBI-BP, CoV in 5 countries, and Sinovac, Coronavac in 3 countries. Madam Speaker, I will now provide an overview of the contents of the National COVID-19 Deployment and Vaccine Interim Plan. The National COVID-19 Plan 2021 covers the following: planning and coordination of vaccine introduction, legal and regulatory framework, phased approach of COVID-19 vaccination introduction in Jamaica, targeted populations and vaccination delivery strategies, human resource management and training, supply chain management, risk assessment and mitigation strategies, vaccine program communication, and vaccine safety monitoring, and COVID-19 vaccine program monitoring and evaluation. So a number of elements of the strategy. Madam Speaker, in terms of the governance structure, a multi-sectoral and multi-stakeholder governance structure has been established to lead the coordination and deployment of the COVID-19 vaccine. This structure includes the previously announced establishment of a National Vaccine Commission to provide strategic and technical oversight to development and implementation of a national deployment and vaccination plan for the introduction of the COVID-19 vaccine in the country. A National Coordination Committee, or NCC, has also been established to design, plan, and provide leadership to the field on all activities related to the vaccination or vaccine introduction. The NCC will guide the priority actions and engage in an ongoing risk assessment so as to ensure that the plan remains relevant. The NCC will be supported by 4 subcommittees: the Parish Medical Officers of Health and the Parish Expanded Program and Immunization Coordinators. The NCC will have responsibility for providing updates on the ongoing assessment of the safety, efficacy, and the duration of protection of the candidates' vaccines. Madam Speaker, in terms of the National Regulatory Authority and regulatory approval pathway, the plan sets out the proposed regulatory approval pathway for the emergency authorization of COVID-19 vaccines for use in Jamaica. The National Regulatory Authority will be responsible for overseeing the licensing and use of COVID-19 vaccines, which will be the Standard and Regulations Division of the Ministry of Health and Wellness. The Standards and Regulations Division has developed an emergency approval regulatory process for COVID-19 vaccine, and the process includes the granting of an emergency use authorization for COVID-19 vaccines to be used in Jamaica, the adoption of the approach taken by the Caribbean Regulatory System, CRS, of the Caribbean Public Health Agency, which is CARFA, or Regional Health Agency, in evaluating and assessing COVID-19 vaccines for emergency use approval by relying on vaccines approved by the WHO and some stringent regulatory authorities such as the US FDA, Health Canada, and the European Medicines Agency. We have also outlined in the plan the application process and documentation requirements for applying for emergency use authorization. In terms of the phased introduction and deployment, Madam Speaker, as indicated in my update to the House last week, there will be a phased introduction and deployment of COVID-19 vaccine in the country. 4 phases for the introduction of the vaccine are proposed. These are Phase 1, vulnerable and priority groups; Phase 2, other priority groups and the introduction of vaccine to the general public; and Phase 3 and 4, more of the general population will have access to the vaccine. In Phase 1, 16% of the population is targeted for the vaccine, with the supply of vaccines to be obtained through the COVAX facility. Madam Speaker, it is also our intention to continuously seek out supplies of vaccines to ensure as many Jamaicans as possible at any given time can be protected. We will seek additional doses of the vaccine based on locally relevant risk factors, vulnerabilities, and the COVID-19 threat. The initial projection for this second phase is a further 16% of the population. Based on whether there is a continued threat of COVID-19, Madam Speaker, Jamaica will enter into this phase, which may be ongoing and will be determined by the need for revaccination and/or the level of immunity achieved or needed by the population. This phase may see the vaccine becoming a part of routine immunization schedules, and procurements will be absorbed into the regular budget for immunization. This will have to be expanded based on demand and availability of funds. So there is still some amount of flexibility which has to be exercised based on what we learn as we go along. Madam Speaker, I have also given instructions to the National Health Fund to survey the market for other options including other private partners, with a view to purchasing these vaccines and making them available to the population. This is in order to ensure that we fill any void or gaps that are there. In terms of vaccine acceptance and uptake or demand communication, Madam Speaker, acceptance and uptake for the approval of COVID-19 vaccine in Jamaica is critical to slowing the spread of the infection, reducing morbidity and mortality, as well as rebuilding the economy. We know, however, Madam Speaker, that introducing a new vaccine, especially through new delivery methods, may be challenging due to public mistrust and misinformation. As such, Madam Speaker, the Ministry will be undertaking a national-level advocacy encouraging citizens to vaccinate against COVID-19. A robust public education and sensitization campaign will be implemented by the Ministry aimed at increasing acceptance and uptake of the vaccine. The purpose of the public education and sensitization campaign is to foster trust of the vaccine and dispel the myths and misinformation, provide factual and accurate information about vaccination, and hopefully in the process gain public input in the vaccination strategies to be deployed. In terms of supply chain management, Madam Speaker, supply chain readiness is key to effectively or efficiently deploying COVID-19 vaccines to the target populations. It is expected that the COVID-19 vaccine will arrive in Jamaica via air, utilizing the transport system in place for the manufacturer to countries participating in the COVAX PAHO revolving fund facility. Once in Jamaica, vaccines, due to their fragility or temperature sensitivity, are given special status by both the Ministry of Health and Wellness personnel and the customs officers at the airport. This allows for timely clearance, transport to central stores where they are checked by the program officer and National Health Fund warehouse staff to ascertain their condition. Madam Speaker, current cold storage capacity at the central and peripheral or parish levels is limited. Given the anticipated overall increase in the number of vaccines, approximately 1 million dosage, additional storage capacity will be required. Each parish will need at least one additional vaccine refrigeration facility to accommodate the COVID-19 vaccine. At the central stores, an additional 10 to 20 freezers, as we know them, will be required and put in place. Madam Speaker, on the issue of financing phase 1, the budget required to support the first phase of this plan is 3 billion Jamaican dollars. This covers, among other things, the purchase of the vaccines, supply chain and cold storage items, PPEs, transportation, staff training, staff costs, public education, and sensitization costs. Madam Speaker, the Ministry has already commenced its preparation activities for the introduction of the COVID-19 vaccines in Jamaica and for the timely and smooth implementation of vaccines once they become available. The Ministry is taking all necessary steps to ensure that safe and effective vaccines are deployed through the continued monitoring of developments related to COVID-19 vaccines, obtaining the guidance of the World Health Organization's Strategic Advisory Group of Experts on Immunization, the Pan American Health Organization Technical Advisory Group, and gathering data to make informed evidence-based decisions to fulfill our mandate of protecting the public health. Madam Speaker, the government has confidence in this interim plan. The Cabinet got a full brief last evening on the plan, and the plan was approved for tabling today. And we want to just encourage the rest of us here in this House and the population at large to make inquiries if that is necessary. But let us recognize that this phase of the response to COVID-19 is a critical phase. We believe it's a phase that will see the beginning of the end, hopefully, of COVID-19 as a primary threat. Not that it will go away, but a primary threat, not just to our population, but to the world. Thank you, Madam Speaker.
over Member Guy. So that's all right. Go ahead.
Thank you very much, Madam Speaker. Minister, I want to thank you for your timely update on this important matter, and more importantly, for your clinical dissertation on vaccine creation. Which Minister, the concern that we have on this side is, as we have expressed before, is the membership on this National Commission. You indicated that our membership will, and our ability to contribute to this will be through the Special Select Committee on COVID-19. But we are yet to have a meeting of that committee, which was promised for some time now, in which we could offer suggestions and bring to the table some of the recommendations that the opposition has. Looking at what has been presented here, however, seem to be a comprehensive listing of some of the things that are required, but there just are a few things that I'd like to ask about. One is the whole matter of the vaccines that are going to be available. We're heartened by the fact that last week you mentioned about approaches by the government in terms of bilateral engagements to see whether we can get vaccines from three countries. And that is also encouraging in light of the fact that, as we have been advised by the World Health Organization, that there's literally, and my coinage, almost a hugging of vaccines around the world by the first world countries, and leaving very much the COVAX facility in some amount of jeopardy because of what is happening, demand and supply and price gouging. The other matter you mentioned, Minister, has to do with the National Coordinating Committee, and you mentioned that there are 4 subcommittees. It would be interesting to know what the 4 subcommittee areas cover there. Also, Mr. Speaker, Madam Speaker, the Minister, you mentioned that there are 4 phases that this program will undertake. The first for the 16% of the population, and the further second for another 16% of the population. The question that I want to ask is, this second phase, how long is it anticipated that the other 16% of the population will it take place to have that program? Because, as you have indicated, the need to urgently immunize the population so that the economy, as well as the other areas, education, can be reopened as quickly as possible, requires at least a 75% herd immunity in the country. So we're looking at the initial second phase, but it didn't say how long that would last for, and that is looking at a total of 32%. Now, the paragraph after that indicated that Jamaica will enter into this phase, which may be ongoing. Which phase is this you're referring to? Is that the third and the fourth phase? Because if certainly it could not be the second phase, which one would infer reading the presentation here, because the second phase is specific in terms of the other groupings as well as 16%. So can you elaborate to say whether this phase that you're referring to is the second or third phase? And certainly, if you look on page 6, you see here where it said the initial projection for the second phase, the end of the first paragraph, is a further 16% of the population. Then the next paragraph said, based on whether there's a continued threat of COVID-19, Madam Speaker, Jamaica will enter this phase, which may be ongoing and will be determined by the need for revaccination, etc. I want to know if it's that you're referring to the third or fourth phase, because certainly it would not be the second phase, because that is already accounted for, and that, as we just indicated, would only capture 32% of the population. The whole matter of vaccine acceptance, uptake, demand, communication, Minister, is very important, because as has been expressed, you have said it, we have said it, the anti-vaxxers are out there and are appealing to many across wide section of the population about the ills, quote unquote, of vaccine. We recognize that there is some potential ills, but the benefits far outweigh the good, and it is why that, as you have said on your side and we have said on this side, we're prepared to take the vaccine, and it's a situation of leading by example so that our population can understand and appreciate that we are not just talking, but we are walking the walk as well. I'm happy to, Minister, in the whole logistics arrangements that you have indicated that customs has been brought into the picture to ensure that there is rapid clearance of that through, and there's no delay in having them held up at customs for that. And it is encouraging because it is an emergency, and I'm glad that those measures have been looked into. There might be others when we can really dissect this particular plan as you have tabled, but for now, that is also one of the areas that we are happy that has been looked at. Finally, Minister, you indicated that the first phase will cost $3 billion, and that at the rate or the price of vaccines, although you have not stated, suggests that outside of the COVAX facility, and what we have been told and read is that in the COVAX facility we are getting about $10–11 per person, per dose. But it is sold at about $30–35 there on the open market. What provisions, or it means therefore that the provisions for the other 86%, 84% of the population is going to be a significant amount. And whereas we are supportive of finding the funds, we would like to know where the government is going to find those funds for that. Minister, it is not until April, I'm assuming, that we'll get the first set of vaccines, or March, but reading or listening to what the WHO has indicated about the challenges, and there's a suggestion by the Director General that it may be delayed somewhat to getting the vaccines under the COVAX facility. It is more important as we look at this to continue to remind our population of the need to have protective measures, the protocols that have been outlined, the social distancing, yes, Madam Speaker, the social distancing, and the sanitation measures and the protective measures, wearing the mask, that sort of thing, until we reach that phase. And finally, Madam Speaker, Minister, you mentioned that you have been advised by your technocrats that persons who have been vaccinated still need to undergo the quarantine period if and when they reach Jamaica. It is something that we need to get further details on, because the process of getting the vaccine and the purpose for getting the vaccine is certainly, as far as we see now, to prevent you from transmitting the disease. So why would it be that you would need to be quarantined for that 2-week period? Thank you.
Thank you. Thank you, colleague, and thank you, Madam Speaker. On the issue of the subcommittees, I think I brought some copies of the plan to be tabled. Or you have a, okay. So if you go to page 12 in the plan, you'll see the org structure for the vaccine, for the management of the process, the Cabinet of Jamaica being at the top, Ministry of Health and Wellness. Then you go to the National Vaccine Commission and Executive Management, then the National Coordinating Committee, and then to your question, 4 subcommittees being vaccine, cold chain and logistics, demand generation and communication, process monitoring and reporting, and service delivery and safety. So that, and the plan is going to be a lot more detailed. It's a 60-page document, well, 50-page here. So once you go through, I am sure, I have no doubt, in keeping with your mandate, you're going to be interrogating the document at our parliamentary special select committee or otherwise outside of this house. So I'd be happy to engage you on that, and the details will be contained here. To the extent that it isn't, we will follow up. The other questions that you asked around the 16% and then what will happen after. The anticipation is that under the COVAX arrangement, you get the 16% during the course of this calendar year, starting with 5% in April and then going further into the end of the year. The second amount would therefore start or commence the following year. But bear in mind also that we have said a lot is going to depend on availability of stocks, how the virus mutates, and whether it becomes a more or less risky or health threat. There are so many variables at play that you really have to be very fluid, which is why we started off the statement by suggesting that. But the anticipation is that the second tranche would be in the next calendar year. Again, a lot depends on access to vaccines outside of COVAX, or to the extent that COVAX can acquire more. It's always better to be with COVAX, because you correctly pointed out that at 10.50 or so under the COVAX arrangement and on the market 3 times that much, it's always going to be better to be there. Now, they are making some conservative projections, so it really depends on how that plays out in terms of approvals and manufacturing, and manufacturing is a big part of the process. So we'll have to comment as we go along. The WHO director has said publicly, I think up to today, that he's very concerned about countries having bilateral arrangements, because what you're doing is undermining a process of trying to serve the world, rich and poor countries. And that's a valid point. So the COVAX system is important, but of course, they say all politics is local, so countries are going to try to look around to see what else they can do to supplement that window. Yeah, 8 doses, yes. And so that's a challenge. The other point worthy of note is that the issue around quarantining after the vaccine and the requirements by the authorities to still quarantine. There is a clinical theory behind the length of or the conclusion is still out as to what that length of time is. I've heard 3 months. So right now the vaccine's implementation has been a relatively short period. So I think it is safe for us to maintain those protocols until we are further advised by the experts. Hence the decision to hold to the arrangements. I think that's it. Thank you very much.
Madam Speaker. Minister, I must say I'm very concerned about the volumes that you've spoken to in your statement. The economy is going through a significant contraction. The tourism industry and related industries like entertainment, restaurants, transportation, etc., are all struggling to survive. Achieving herd immunity in the population is critical not only to our public health, but also to our economic recovery. And to hear that the government's ambition is to achieve 16% of the population being immunized in a year, and then it's not to the following year that we might have another 16%. When to achieve herd immunity, the general consensus is it's around 60% of the population that must be immunized. I think that is unsatisfactory. We must aim significantly higher than that. Jamaica, in my opinion, should do its utmost to source sufficient doses to immunize our population this year at a level that will achieve herd immunity this year. We have a very capable public health apparatus. Once we're able to source the vaccines, the distribution of them, I think is something that we can cope with. And of course, the public education around it is going to be tremendously important. And it will always be a voluntary thing as to whether somebody chooses to get vaccinated or not. But the dangers of the disease are such that one would expect people to take a rational decision if they're given full information. Other countries, Israel has already achieved 16%, that's a week ago, of their population. I don't know where they are now. I know the UK has done over 4 million people already. We must step up this effort, especially, I think, the non-COVAX efforts, because the COVAX system seems to depend on the goodwill of nations at a time when each country is very anxious to try and recover, because each country is facing the tremendous stresses caused by this pandemic. We need to do what is right by our people, and we need to have a very concerted effort to source vaccines, safe vaccines, from whatever the legitimate sources of supply are, and achieve herd immunity this year. And I'm asking you to look at that again, Minister, and see what can be done. I don't know who is in charge of trying to source these bilateral arrangements, but that needs to have a very high-level team with the capacity to go out there and source, negotiate, and so on. Some of the viruses are significantly less than 30 US a dose. I know, for example, the AstraZeneca one is in the single-digit range. So, you know, and that is being produced in various countries. I believe Mexico are going to be producing it for this region, based on what I've heard. So let us be a bit more ambitious, significantly more ambitious, Minister. The economy and the society are depending on you to deliver on this year. Thank you, Minister.
Minister, first of all, let me join in thanking you for presenting what is an interim national deployment and vaccine plan. I had expressed concern elsewhere about the lateness of this plan in coming forward, but I'm pleased to... Is it working? Yeah. Yeah. No, can you hear me? No. So I was making the point that I'm pleased to see that at least is it a draft plan, or is it a draft plan? I know it's interim, but is it draft in draft form, or is this a final? Yes. And I'm making the point that I'm pleased to see that it has come forward, because I think it is very critical and urgent that we do so, because I think the evidence is very clear that even in developed countries, some of them larger than we are, much larger, others like Israel, probably a little closer to what our population size, although they are still larger. But the evidence is clear that unless there is such a plan that is well rehearsed, that there will be significant problems and challenges in its deployment and administration. So at least it's a first start. Minister, as I peruse the plan, I'm not seeing anything in the plan to date about security. Yes, and I believe that is something that cannot be underestimated, that the plans, that these vaccines, when they arrive, you will find that there are others that have interest in it other than the legitimate and assigned users. So I'd like to see an element of security for that. But as I've said, and others before me have said, the deployment and administration of this is very critical to the economy and the society as a whole. But this is a start, and I look forward to the meeting of the committee to interrogate this more closely. Thank you.
So, Madam Speaker, quickly, in response to the leader of the opposition, I just want to say that I fully appreciate his anxiety and the anxiety of some persons in the population to have a vaccine as quickly as possible. But you know, we are faced with a very practical scenario, and that is that you can't access what is not available. And that is the real challenge that we face, and I say this respectfully. I mean, it's one thing to say we need to achieve 60% to get to herd immunity, but if the supplies are just not there, they're just not there. I mean, you cite a country that is at the top of the list in terms of being aggressive in vaccinating, Israel. Israel is less than, I think last week it was 12%, but you're saying 16.5, so it's 16%. And the same, it would be less for the UK based on their population and the 4 million. It would be far less for the US, and I could go on. So industrialized countries with significant amount of resources and that have done much worse than us and who are even more anxious because of their economic issues, as you have cited, are far less able, it appears, and it is the case, to provide more vaccines to the population. So, you know, it's an aspirational position, but it doesn't, it really cannot be placed in the realism of the situation that is here now, and that's something that I think the members should bear in mind. Where I think the anxieties can be addressed, and I would call on the member to play a role here, Madam Speaker, is in overcoming the anxieties in the population around the efficacy and the safety of the vaccine once it gets here. Because I do believe that while there is a fair bit of the population willing to take the vaccine, the whole issue of vaccine as an option is becoming is being placed into a very controversial situation as it relates to the safety and efficacy. And we are going to need a bipartisan approach to ensure that the vaccine is taken up so that we can get on the road to recovery as quickly as possible. So the other point I want to make, Madam Speaker, through you, is that the 16% is a conservative figure, and I do believe that we will get more during that period of time, but I think that the COVAX facility and the experts at WHO and PAHO, having had the best vantage point to review all the research that is taking place and the production that's taking place, are giving a very conservative estimate. But hopefully things will happen a lot faster, bearing in mind that we have to balance the need to have a vaccine and the need to have a safe vaccine. Because if anything should go awry in our population, some adverse effect on a sufficient number of the population, because there's always a margin of error, you can imagine the backlash that would have on all of us. So we have to be very careful, but it's not to say we're not moving speedily ahead. And then the final point around the interim versus whether it was a draft. So I did say in my presentation that it was interim, but it was, as it says here on the front, but it's interim not because we are in any doubt about where we need to go, but because the situation is fluid and things could change. So we will review and update as we go along. So if it is a plan that we are working towards achieving based on the current status in the population and in the world. Thank you, Madam Speaker.
No. I did ask about the security plan.
Right. So on the security, Madam Speaker, I mean, you know, we have to ensure that the security means protecting the integrity of the product, so it's not compromised. I don't know if your concern is about persons maybe trying to get access. That's a matter. So one of the 4 subcommittees around monitoring and reporting would capture the arrangement of preserving the product and ensuring that the product gets to the population that is targeted. And that would be there would be a security feature there.
Announcements.
Laid on the table of the House today are the following: annual report and audited financial statements for the 2019-2020 financial year of the National Housing Trust. The third, supplementary estimates of expenditure for the financial year ending March 31, 2021, and the National COVID-19 Vaccine Development and Vaccination Interim Plan.
Petitions, papers. I beg your pardon. My apologies.
The following is a message from the President of the Senate to the Honorable House of Representatives. I have the honor to advise the Honorable House of Representatives that on the 15th day of January 2021, the following bills were passed in the Senate. A bill shortly entitled the Evidence Amendment Act 2020, passed without amendment. It should be 21. A bill shortly entitled the Dangerous Drugs Amendment Act 2021, passed with 6 amendments, for which the Senate desires the concurrence of the Honorable House. Signed, Thomas Tavares, Finson OJ, CD, QC, JP, President of the Senate.
Minister Chuck.
Madam Speaker, I now ask for your consent that the Senate amendments to the bill shortly entitled the Dangerous Drugs Amendment Act 2020 be now considered and approved.
Consent is given, Minister.
You want to touch on it?
Just crave our indulgence. Just take something. There is a clause 48 that a clause 4C should not refer to giving notice where a warrant is.
Speak to it now. Speak to it.
Let me see the bill. Where is it?
Madam Speaker, the amendments proposed by the Senate has been circulated, and basically we do approve of these amendments in clause 1, the following clause: amendment of section 21 of the Principal Act. Section 21 of the Principal Act is amended A in subsections 4 and 5 by inserting next after the word premises where it appears, in each case the words or other place. B by inserting next after subsection 6 the following subsection. 7 in this section, other place includes a conveyance. In respect of clause 2, Madam Speaker, in subsections 1, 2, 3, and 6 of the new sections 21A, insert in each case after the words section 21(4) and subsection 5 the words or any other law. 2 in subsections 2B and 7B2 of the new section 21A, in each case delete the words government chemist or analyst designated under section 17 of the Food and Drugs Act and substitute therefore the words public officer who is assigned duties in the Institute of Forensic Science and Legal Medicine. 3 in subsection 4B of the new section 21A, delete the words unless it is impracticable to do so, and B in subparagraph 2, insert next after the word representative the words unless the defendant or the defendant's representative fails to appear, therefore after the notice is given in accordance with paragraph A. Madam Speaker, in respect of the new clause 3, insert next after clause 2 the following clause. 3. Section 27 of the Principal Act is amended by deleting the words quote, government chemists or any analyst designated under the provisions of section 17 of the Food and Drugs Act, unquote, and substituting therefore the words, quote, public officer who is assigned to perform duties in the Institute of Forensic Science and Legal Medicine. Madam Speaker, these are the proposed amendments by the Senate. I see no objection, so I'm asking, AG, and I'm asking for the House to approve these additional amendments from the Senate, and if this is agreed by the House, we ask for its approval.
Those in favor?
Well, I just... okay, Madam.
You
Approve.
asked.
Aye.
So those in favor? Aye. Those against? The ayes have it. Members, there's a heavy murmur. I can hardly hear the speaker. Please keep your voices down. Can't hear the speaker. Petitions, papers, reports from committees, notices of motions given orally.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move whereas Section 22 of the Electricity Act 2015 provides that provisions of the Act shall be reviewed by a joint select committee of the Houses of Parliament 5 years from its date of commencement, and whereas the commencement date of the Act was December 22nd, 2015, be it resolved that notwithstanding Standing Order 76-1, this Honourable House of Representatives appoint a special select committee comprising of the following members: Honourable Darrell Vaz, Chairman; Honourable Robert Nestor Morgan; Honourable Xavier Main; Honourable Floyd Green; MP Tova Hamilton; MP Robert Miller; MP Philip Paulwell; MP Fitzjackson; MP Anthony Hilton. To sit jointly with a similar committee to be appointed by the Senate to review the report on the Electricity Act. Madam Speaker, I further beg to give notice that at a later stage today, I'll move with the suspension of standing orders to enable me to take the motion. Thank you.
Minister Finance.
Madam Speaker, I beg to give notice at the next meeting of the House. I will move, be it resolved that the third supplementary estimates of expenditure for the financial year ending March 31st, 2021, which were laid on the table of the House on the 19th day of January 2021, be referred to the Public Administration and Appropriations Committee of the House of Representatives for consideration and report. Madam Speaker, I further beg to give notice that at a later stage today, I'll move for the suspension of the standing orders to enable me to take this motion.
Madam Speaker, I beg to give notice that at the next meeting of the House, I will move the following motions. Whereas subsection 1G of section 41 of the Constitution of Jamaica requires a member of this Honourable House of Representatives to vacate his seat if any firm in which he is a partner or any company of which he is a director or manager becomes a party to any contract with the Government of Jamaica for or on account of the public service, or if he becomes a partner in a firm or a director or manager of a company which is a party to any such contract. And whereas the Member of Parliament for St. Thomas Easton is a director of the following entities: 1. Mishals Enterprise Jamaica Limited, which provides medical, dental, spa, clothing, and real estate development services. 2. Jamie's Investment Company, which provides medical, dental, and real estate development services. 3. Luce Land Farm Hers, which is involved in the farming, product retail, manufacturing, agriculture, and processing industries. 4. Jamaica Conduit, which provides finance, employment, and consultancy services. And 5th, Posh Party Coordinators, which provides events planning services and coordinates charity events. And whereas these entities may from time to time enter into contract
with the government of Jamaica and its affiliated agencies. And whereas the member has disclosed her interest in these entities, be it resolved that this motion be referred to the Ethics Committee of the House of Representatives for consideration and report. Madam Speaker, further motion, whereas subsection 1G1 of section 41 of the Constitution of Jamaica requires a member of this Honourable House of Representatives to vacate his seat if any firm in which he is a partner or any company of which he is a director or manager becomes a party to any contract with the Government of Jamaica for or on account of the public service, or if he becomes a partner in a firm or a director or manager of a company which is a party to any such contract. And whereas the Member of Parliament for Kingston, Easton and Port Royal is a partner in the law firm Paulwell, Fraser, Binns and Associates, and whereas this entity may from time to time enter into contracts with the Government of Jamaica and its agencies, and whereas the member has disclosed his interest in the above entity, be it resolved that this motion be referred to the Ethics Committee of the House of Representatives for consideration and report. Madam Speaker, there is a third motion. So whereas Standing Order 73D-C requires the Integrity Commission Oversight Committee to review the annual report and any other report of the Commission and submit recommendations in relation thereto to both Houses of Parliament. And whereas during the previous Parliament, the Integrity Commission submitted several reports which were referred to the Integrity Commission Oversight Committee of that Parliament. And whereas the required review of the report so referred was interrupted by the dissolution of that Parliament, be it resolved that the Integrity Commission Oversight Committee be hereby empowered to review those reports of the Integrity Commission which were laid on the table of the House immediately before the dissolution of the parliamentary term be considered. Madam Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take those motions. May it please you, Madam Speaker.
Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to sittings of the House. Motions for leave to introduce bills. Presentation of bills without leave of the House first sought. Minister Clark. Microcredit bill. Presentation of bills without leave of the House first sought.
Madam Speaker, I now move to introduce and have read a first time a bill shortly entitled the Microcredit Act 2021.
A bill shortly entitled the Microcredit Act 2021, read a first time.
Madam Speaker, I beg to give notice of a second reading of the bill. And Madam Speaker, I further beg to give notice that at a later stage today, I'll move for the suspension of standing orders to enable me to take a second reading of the bill.
Public business.
Madam Speaker, it is intended to have the debates relating to the Microcredit Act, the Independent Fiscal Commission, and of course, Madam Speaker, I will take the motions that I gave earlier on, as well as the third supplementary estimates, which the Minister of Finance will do. May it please you, Madam Speaker. So, No, sorry.
As
No, sorry, Madam Speaker, I'll just take the motions and then Minister Vaz.
very well.
Right.
Very well.
Madam Speaker, I now move for the suspension of the standing orders to enable me to take the motions of which I gave earlier, particularly two in relation to the reference to referral to the Ethics Committee, and the third, of course, in relation to the Integrity Commission.
Members, the question before the House is that the standing orders be suspended to enable the Minister to take the motions, notice of which he gave earlier. Those in favour? Those against? The ayes have it. Minister?
Madam Speaker, I further
No,
beg to give...
just a minute.
Oh, you're finished?
Madam Speaker, I now move that the motion, notice of which I gave earlier, be approved.
The question before the House is that the motions, notice of which the Minister gave earlier, be now approved. Those in favour? Those against? The ayes have it. Minister Vaz?
Thank you very much, Madam Speaker. Madam Speaker, I now move for the suspension of the standing orders to enable me to take the motion and notice of which I gave earlier.
The question is that the standing orders be suspended to enable the Minister to take the motion, notice of which he gave earlier. Those in favour? Those against? The ayes have it.
Madam Speaker, I ask that the matter, the motion that I gave earlier, be approved.
The question is that the motion be approved. Those in favour? Those against? The ayes have it.
Madam Speaker, I propose to take the Independent Fiscal Commission Act first. The debate had commenced last week, January 12, 2021, and I'd invite other members to take part in that debate.
Member Robbins.
Madam Speaker, the opposition, by and large, is in support of the Independent Fiscal Commission bill. There are just a couple of questions that I have for the Minister. In section 13.3, it states that the Commissioner shall not consider any alternative policy. Now, there are a number of clauses in the bill related to the independence of the Fiscal Commissioner, which is absolutely important. I just question why the Commissioner would be restricted from opining on anything that could be considered an alternative if he or she believes that the policy framework that the government may be embarking on is inconsistent with the achievement of the fiscal objectives. Secondly, again related to the independence of the Fiscal Commissioner, I know there is a provision for both a pension and a gratuity. The question I would ask is it envisioned that the terms of the Commissioner would be similar to what a puny judge would enjoy, or the equivalent of once a person becomes pensionable, they are guaranteed a full pension. With the gratuity, a gratuity assumes that there will be some assessment done, if that is the case, of the performance of the individual. And if that is so, who would do that? And if it is not so, if it is automatic that you're going to get a gratuity, I don't think that's necessarily a good precedent to establish. So I believe the model of what exists with some other commissions, like the ECJ, is the model that I believe should be adopted. The advisory committee can be appointed for a 3-year period. There is no cap on the reappointment of that advisory committee. And I believe you should probably look at a maximum of 3 consecutive 3-year terms for any individual, so that you don't have advisory committee members becoming institutions in and of themselves. And that in the same way that there is a specific time limit on the Fiscal Commission of 7 years, there would be a specific time cap on how long somebody could serve on the advisory committee. But those are my comments, Minister. Again, I know the opposition leader has some, but by and large, this is something that we support and agree with.
Thank you, Madam Speaker. Madam Speaker, the establishment of a fiscal council was something that we on this side had been calling for, really arising out of the experience of EPOC as an institution, an indigenous institution created here in Jamaica in 2013 when we entered into the standby agreement with the IMF in that year. And EPOC was essentially a negotiated institution with co-chairs from the public and private sector, and was really mandated to review the performance of the country against the commitments that had been given in the IMF agreement, which involve significant sacrifices by many sectors of the society, and monitoring and reporting to the public on the degree of compliance and performance with those commitments. It is an institution which attracted the attention of the very top of the IMF when Ms. Lagarde came here to visit us, I think in 2015. She publicly approved of ESOP as a novel institution that essentially facilitated ownership of the reforms by the public at large, by building a higher level of trust in the society around the economic program and the rather difficult set of reforms that were necessitated to transform Jamaica's fiscal outlook and future. With the IMF agreement coming to an end, it was understood that the mandate in terms of reference of EPOC would also come to an end, because EPOC was essentially a creature of the IMF agreements. And a response to that, the government of the day entered into a memorandum of understanding, I believe, which extended the life of EPOC beyond the cessation of the IMF agreement. And indeed, EPOC is still functional as far as I am aware. I get monthly reports or periodic reports from them on the performance, which they gauge not against an IMF agreement, because Jamaica has not been in an IMF agreement for a couple of years, but against the government's targets as the government has articulated them and shared with the public. But that was always seen as an interim measure, and the idea was to institutionalize through legislation a fiscal council, which is a construct which is not novel to Jamaica, but is something which has emerged in many countries as a device to ensure that there is professional monitoring of the government's fiscal program and reporting on compliance with whatever the fiscal targets are. In our case, we have a fiscal responsibility framework which has been enacted in law, the Act, which of course has as its main focus the reduction of the public debt to sustainable levels. Initially, the target date for achieving that was the end of March 2026. As a result of the impact of the COVID pandemic, the government passed legislation in 2020 to put that target back by 2 years to March 31, 2028. But in order to achieve that target, there are fiscal decisions that have to be made each year to run the necessary primary surplus and overall balances that will enable the debt to be paid down as the economy hopefully grows. And the Fiscal Council is the body being established. It is going to be called a Fiscal Commission to achieve that on an ongoing basis. So it is not a controversial piece of legislation. It is something that we had been calling for in budget debates over the last few years. And indeed, it is rather late because it ought to have been in place at the time that the IMF agreements came to an end. But for one reason or another, that couldn't be done. And we are where we are now, and it is being done now. I want to thank the Minister for giving us a few weeks to look at the legislation, which was tabled in December. He was anxious to pass it, but he did say that he would give a few acquiesce, thank you, and allow us a few weeks to look at it. I endorse the comments made by the Shadow Minister of Finance on the bill, and I have a few other points I just wanted to bring to the Minister's attention. They're really more drafting issues, I think, than matters of great substance, but nevertheless, I think that they're worth bringing to your attention. The first point I just wanted to make was, in the bill, there is language that refers to staff, and there's language that refers to officers and agents. So, for example, in Clause 3, Subclause 3B, on page 4 of the bill, the Fiscal Commission shall carry out its functions through such staff as may be necessary. On the other hand, in Clause 10, subclause or subsection, subclause 1, it speaks to the Fiscal Commissioner may appoint and employ for the purposes of this Act at such remuneration and on such terms and conditions as may be approved by the Commission constituted under Section 8.4, such officers and agents. I don't know why we use the word agent there, because agents are not typically employees of an institution or an employer. And we use the word staff. For example, in Clause 12, in the opening words of 12.1, there's a reference to every person appointed to the staff. So there is this inconsistency in the language in what is really referring to the same thing. And I would suggest you consider using a uniform approach, because it does reduce the opportunities for misunderstandings or misinterpretations of the legislation. The second point I wish to make relates to page 5, and this is Clause 4 of the bill, 4.4 and 4.5, and it's to do with the removal of the Fiscal Commissioner from office. 4.4 says that the Fiscal Commissioner may be removed from office for the inability of the Fiscal Commissioner to discharge the functions of his office, whether arising from infirmity of body or mind, dereliction of duty, or misbehavior, and shall not be so removed except in accordance with the provisions of this section. The next subsection, 5, where it says, where each House of Parliament by resolution decides that the question of removing the Fiscal Commissioner from office should be investigated, then, and it goes on in B to say, that tribunal shall inquire into the matter and report on the facts thereof to the Governor-General and advise the Governor-General whether the Fiscal Commissioner ought to be removed from office for inability to discharge the functions of his office as aforesaid, or for misbehavior. It doesn't track the language of 4, which is where the grounds upon which removal can be based are set out, and they ought to be consistent. And specifically, the words dereliction of duty are omitted from 5B, and I think they ought to be included there. I move to Clause 7 of the bill, which is to do with the funding of the Fiscal Commission. And it speaks to, in subclause 3, it says the Fiscal Commissioner shall at such time within each year as the Minister may direct, submit to the Minister for approval the estimates of expenditure for the financial year commencing on the 1st day of April the next following. This goes to the independence of the institution we're creating. It doesn't have any mechanism for arbitrating what happens if the minister doesn't approve the proposed budget put forward by the Fiscal Commissioner. And if, to the extent that the Fiscal Commissioner were not to be adequately resourced to do their job, the oversight function, which is critical to the construct that we are developing in this legislation, would not be achieved. So, to my mind, the legislation ought to include a mechanism for resolving any such difference, which maintains the independence of the Office of the Fiscal Commissioner. The funding of the Commission being absolutely fundamental, of course, to their ability to execute their responsibilities and functions satisfactorily. I move to page 9 of the bill, and this is clause 10, subclause 3b. The words in the last 3 lines of 3b are really closing words which govern A and B and ought to go back to the margin. So there ought to be a comma after Fiscal Commission and the words that follow. And such arrangements or regulations may include provision for the grant of benefits to the dependent and the legal personal representative of such officers ought to go back to the margin. I move to page 10. Who is this? Nigel, sorry, what you are? That was 10.3b. 10.3b on page 9. I move to page 10 of the bill, clause 13.3, and the member for South East St. Andrew has already spoken to this. It's a very critical provision in the bill because it speaks to the scope of the work of the Fiscal Commissioner. And it says that in carrying out the functions of the Fiscal Commission, the Fiscal Commissioner shall only have regard to the policies of the government in this regard and shall not consider any alternative policies. So the Fiscal Commissioner is essentially a mechanistic entity that is looking at what the government is doing and assessing its compliance and with what the fiscal responsibility framework requires the government to do. It is a comparison in that respect. There may be other functions, but none of those other functions can include any form of discussion or criticism of government policy in the area of the financial affairs of the country. It's a very narrow mandate, and it's a mandate which I think the wider public would find surprising that as legislators we're going down this route, because we're setting up a new entity now, which is going to be a charge on the taxpayers of the country, but we're deliberately restricting the scope of its functions to only looking at what is being put forward by the government and assuming that that is a fixed given and is not, the Fiscal Commission is not about suggesting alternatives, another way of doing this or another way of doing that. Really, it's just an analysis of what's put before him vis-à-vis the specific fiscal targets that are set out in legislation. And I just bring it to the public's attention because I do think that this is something which may be subject to some puzzlement in the minds of the public or some sections of the public, and maybe something that we will revisit in the future. On page 11, Minister, in 13.7, there is a provision there that deals with the delegation of functions by the Fiscal Commissioner. And it says that it is declared, in the interest of certainty, that a delegation under subsection 4 shall, in addition to conferring authority to exercise the delegated function, also subject the delegate to the same obligations as would apply under this Act to the Fiscal Commissioner's exercise of that function or such function, and accordingly, the delegate shall be liable for any wrongful act or omission of the delegate occurring in the exercise of that authority. It occurred to me when reading this that ought to be subject to Section 11, which is a protection of the Fiscal Commissioner and officers provision, where Section 11 says, or Clause 11 says, that the Fiscal Commission, every person appointed to the staff, shall not be held personally liable for any act or default done or omitted to be done in good faith. And I think that that provision in relation to delegates ought to be brought within the ambit of 11 as well. And I think it should be. So I was suggesting after the word accordingly, the word subject to Section 11 be inserted in subclause 13.7. On the same page, Minister, clause 14, there's a provision which I'm not sure I understand. It says, 14.1 says, the Fiscal Commissioner may at any time require any officer or member of the specified public sector, subject to their enabling law, to provide the Fiscal Commissioner with such relevant information as the Fiscal Commissioner may deem necessary to assist the Fiscal Commissioner in carrying out the functions under this Act. In reading it, it occurred to me that none of the existing enabling laws would make any provision for sharing of information with the Fiscal Commissioner. So rather than being subject to their enabling laws, it really should be notwithstanding their enabling laws. This provision should apply even if there is nothing in the enabling laws that allows them to share this information. So I think that ought to be considered again, because if it's not so, then you're going to find the silo effect that we have seen in the past, for example, in relation to the Corruption Prevention Commission, which was unable to get information from other law enforcement entities in the public sector because the enabling laws didn't specifically allow it. And the Integrity Commission Act that has passed has eliminated those silos. And I think that ought to be the case here, that the Fiscal Commissioner should be empowered, whatever the enabling laws of the other public sector MDNAs may say, to require them to provide the information that is required to do his job or her job, especially given that there is an obligation of absolute secrecy in Clause 12.2 on pain of criminal prosecution in relation to the persons who work within the Fiscal Commission. They have to deal with all of the information they receive as secret and confidential. So that protection exists. Moving to the following page, Minister, page 12. This relates to the Economic and Fiscal Assessment Report that the Commissioner is to prepare, and it requires that it be published on the official website of the Fiscal Commission within 10 days of the laying of the fiscal policy paper before both houses. And it just seemed to me that was a little short. I noted that in Clause 3.2b, it spoke to a longer period in relation to the reports that are referred to there. It gave 2 weeks, and I was wondering why we didn't standardize that period, because obviously the analysis and review and analysis is going to be very important, and I don't think shortchanging the Fiscal Commissioner a few days is advisable. In subclause 3 on page 12, that is 15.3 on page 12, it makes reference to subsection 6. It says, subject to subsection 6, the statement on fiscal performance shall provide, etc. I think that's a wrong reference. I think it ought to refer to subsection 4. You can have a look at that, Minister. I note that on the same page, subsection 4 says, in preparing the Economic and Fiscal Assessment Report and the Statement of Fiscal Performance, the Fiscal Commissioner shall ensure that no information is included which is A, confidential, or B, if disclosed, could prejudice national security or defense of Jamaica or have a substantial adverse effect on the Jamaican economy or on the government's ability to manage the Jamaican economy. it seemed to me, though, that if you look back at 13.2, which says that the Fiscal Commissioner shall carry out the functions of the Fiscal Commission in an objective, transparent, and impartial manner, that this obligation to muzzle the Fiscal Commission in relation to these things ought to be made subject to 13.2. So if 13.2 applies, then it should apply across the board. And information which is conducive to the Fiscal Commissioner carrying out the functions of the Fiscal Commission in an objective, transparent, and impartial manner ought to be permitted. The 17, clause 17 on page 13, Minister, says that the Governor General, by instrument in writing after consultation with the Minister of Finance and the Leader of the Opposition or the person designated by the Leader of the Opposition to be the spokesperson on finance. I don't know why you have an alternative there. Let's choose one or the other. You know, I don't think you should be cherry picking to whoever you think would give you the GG an easier ride. On page 14, looking at 17.9, subclause 9, it says that the Governor General may, by notice in writing, revoke the, and this is dealing with the advisory committee. The Governor General may, by notice in writing, revoke the appointment of a member of the advisory committee for the inability of the member to discharge the functions of his office, whether arising from infirmity of body or mind, dereliction of duty, misbehavior, or for any other cause. In 4.4, which dealt with the removal of the Fiscal Commissioner, it didn't have that language, or any other cause, which is very wide. It spoke to infirmity of body or mind, dereliction of duty, or misbehavior. And I think the two should be consistent. So either add those words in the first provision or take them out of the second provision. I think they're rather wide myself. Minister, that is really the extent of my comments on a specific text before us. As stated, it's legislation that is important and that really amounts to the performance of a commitment that was given to the country through the IMF agreement that this would be done. It is being done later than had been originally envisaged, but in the meantime, EPOC has continued to function and function well. And I want to use this opportunity to thank, in particular, well, the members of EPOC over the years, but in particular, the original chairperson from the private sector, Richard Biles, who played that role in a way which I think inured to the benefit of the country, because he was dispassionate, and he was objective, and he was balanced. Even at times when the political class, or some members thereof, were critical of him for things that were said or not said, he stood his ground and executed that function with aplomb and dignity. And I think that his successor, Keith Duncan, has also acquitted himself well in that position, and I wish to congratulate and thank him, both of them, for their service over the years. I hope, Minister, that you're able to find a fiscal commissioner who fits the bill, pardon the pun, and that will enable this important institution to get off to a good start and to enrich the overall fiscal architecture of the country in the way that this legislation contemplates. And I reiterate that you have our support in the passage of the bill. Thank you.
thank you, members, for the contribution to the bill. I'm not going to, there are one or two things that AG is advising us to check on, so we're not going to push all the way through, but maybe next week or something like that. But maybe I respond to the one or two the things that the first matter is the matter of scope, which was first mentioned by the opposition spokesperson and by the opposition leader, with the clause that says the Commission will only be focusing on the policies of the government, will not be focusing on alternate policies. Now, this is very deliberate, and bear in mind what I have said last week at the introduction of the bill, that we would have, this is an area where we'd have depended significantly on advice from others who have independent fiscal institutions, like Canada, as well as from the fund and from the IDB. This is certainly one bill that has had multilateral and bilateral input. Now, the purpose of that clause is to focus the Commission on its duty to ensure that and by ensure is not even the right word, but to report on the government's fidelity to a credible fiscal path. Once the envelope of expenditure, of revenue and expenditure, are consistent with a credible fiscal path as defined by Part 7 in the Fiscal Responsibility Framework, then that is the end of the Commission's responsibility. It is within the ambit of the government of the day to make its own social policy choices, whether you believe in school vouchers or you believe in some other way of supplementing schools, or you believe in, healthcare in a particular way or healthcare in another way. That's a social policy choice of the government in question. And the analogy, right? Because remember what we're doing is we're trying to make permanent the kind of conditions, the forces at work, the transparency, the provision of information that were a part of our fiscal transformation. And the analogy I'd make is that during two successive fund programs, we would have agreed primary balance targets with the fund, would have agreed legislative reforms and even policy reforms. But within that envelope of expenditure that was consistent with that primary balance, there was no, the fund, Jamaica, is free to pursue its own policy choices within that envelope. So yes, by definition and by design, the ambit of the Fiscal Commission is very specific. But within that ambit, it has a lot of power to discharge its functions within that very specific ambit. And the ambit is multifold, but to pronounce on the macroeconomic policies and whether they are consistent with the fiscal responsibility framework, and in particular with the debt targets that are a part of that fiscal responsibility framework. The question on the pension, pension and gratuity. For other commissions of Parliament, the legislation at the time of its passage didn't properly deal with pension and gratuities of staff of the Commission and even the commissioners themselves in one or two instances. And now the Ministry of Finance and Public Service is in receipt of communication and trying to solve those challenges after the horse has bolted. So we wanted to make sure for this fiscal commission, for this Commission of Parliament, we set out very clearly what the pension and gratuity entitlements are. The word pension and gratuity is used in the document in a way that's consistent with how we think of pension and gratuity in the public service, in that the fiscal commissioner becomes pensionable if the fiscal commissioner serves 7 years, or if the fiscal commissioner retires on ill health grounds. If the fiscal commissioner vacates office for any other reason, he or she is not pensionable. Now, if he or she is pensionable, then the fiscal commissioner can elect to receive a reduced pension, as occurs in the public sector. And with the reduced pension, you get a lump sum, which is called a gratuity. So that is with respect to the fiscal commissioner, that is the manner in which it is referred to. Right? And the idea for those on contract, right, the idea behind that's a different kind of gratuity where you get at the end of your contract period. The suggestion on the cap on the advisory committee member is not one I find offensive. I think that that's a reasonable suggestion. We can find ways of incorporating that. Clause 7 of the bill, I was distracted when I heard one or two of the earlier comments, but Clause 7 of the bill that deals with the submission of the estimates of expenditure. I mean, again, this provision is very similar to other provisions for other independent bodies, whether the Integrity Commission or even the Auditor General. They submit their budgets. Even the judiciary's budget is submitted, and it's just what the law, the independence is represented or is observable in the fact that you just give a line item budget today for the judiciary, right? You leave the judiciary to allocate the resources how they see fit. But the Ministry of Finance provides X dollars for the judiciary, and similarly for the Integrity Commission. And they then apportion that the best way they see fit. But at the end of the day, Parliament, it's Parliament that approves the budget, and Parliament cannot be shackled in that duty to allocate the people's resources. And those are the principles that are sort of intention, the principle to allocate the resources, but you leave it up to, at the top level, and you leave it up to them to allocate it within there. But it's not an issue that's unique to this. And we might need a solution at some point with the, yes. Yes. Yeah. So before what it used to be is that we'd provide we'd provide detailed budgetary allocation for the judiciary. So we could determine here how much money, and I'm just going to give examples off the top of my head, but how much money goes into, cleaning the courtroom and how much goes to compensate, how many we could allocate in detail. And yes, I believe it was under your time that a change was made to have a line item for the
It's not just that, but the process for developing the budget for the judiciary, for the justice system, well, the court system essentially, had a specific process in it, which was unique to that. There's no other part of the sector, public sector, that has that particular process, which ultimately resulted in the line item. But that wasn't even prescribed in the law itself. That was what was seen to be an appropriate accounting mechanism as a result of what the law required. But there was a sort of negotiation process almost built in to the process, So here there isn't one. And as you say, maybe sometime down the road we will think these things through in terms of really ensuring financial independence. Because yes, the Parliament ultimately has to approve the budget, but the Minister of Finance is typically from the majority side, so he's fairly assured of some cooperation.
Yeah, so that's the thing about these things. At the end of the day, right, the people have to remain vigilant. There's no system that we can put in place that absolutely protects under all situations. The people, at the end of the day, it's a people's democracy, and the people have to remain vigilant and to hold their leaders to account, to hold their government, hold their opposition to account. We can make best efforts here to create institutions, but there'll always be opportunities for misguided, and it'll never be perfect. With respect to the some of the details, like subject to the enabling laws, those I would deal in committee and so on. Right? The 10 days. I mean, I think what we're saying there is that the Fiscal Commission has the authority to, within a specific period of time after it has been tabled to the House of Representatives to publish it on its website. Mandatory obligation, which is an advance. You will recall that in other... Right, I understand that. But it's just it's responding to the society, which in other commissions has called for commissions not to wait, right? So we're saying on a mandatory basis, you publish the reports on the website. And remember that we want to be true to our experience. Our turnaround happened in the context of EPOC reporting directly to the people of Jamaica, not coming here to Parliament, for better or for worse. It did not happen inside here, right? It happened with EPOC facing the public at large. And so we want to retain that element, that this entity is facing the public at large. Yes, it comes to Parliament, and yes, Parliament has their role, but we're not waiting on Parliament. We're sending it to the people. And the people have ways of making sure if they're concerned, they can channel those concerns. The thing about when you say, I can't remember, I just want to be faithful and try and respond to your things, what you said. You characterize 15.4 as saying Muslim. When we said, in the preparation of the economic and fiscal assessment, the Fiscal Commissioner shall ensure that no information is included which is confidential or, if disclosed, could prejudice. Here, what we're getting at here is that there's a lot of information that will come by. I think that's what you had said, 15.4, that should not be a part of what they publish, right? I mean, at the end of the day, the most important part is, the paragraph of their opinion, and we have to preserve information that could prejudice national security, defense, or is otherwise confidential. With respect to the matter on the cooperation with other public bodies, this is important. What happens now with other bodies who have this type of independence is that they enter into MOUs with other bodies, and then those MOUs allow them to be faithful to their enabling laws, and they share information in a way that's consistent with those MOUs. No, I'm not saying I can't speak for every single one. I can speak for ones in my ministry that they, and who share with others as well. There are MOUs in place, and what we're seeking here is we're giving the Fiscal Commission enormous power to have access to information that's relevant to its work, but we do know that there are existing laws in place that protect individuals and call for information to be treated in a particular manner. And what we envisage is that the Fiscal Commission, once it gets started, they're going to enter into MOUs with various departments of government that will prescribe how the information ought to be, how it's obtained, how it's used, and where the liability lies. Right?
MOUs are good practice because they ensure an orderly way in which the sharing takes place. How requests are made, to whom, by whom, and how it's presented, etc. But I'm talking about the legal authorization to share it at all. And I'm saying if you're talking about bodies in the public sector that have a statutory framework, if those enabling laws don't authorize the sharing of information, the Fiscal Commissioner will not be able to get it, especially when 14.1 says it's subject to those enabling laws. I'm saying because those enabling laws already exist, this should trump that, and they should be able to get it. That, subject to whatever protocols, MOUs, etc., are appropriate. Yes, I accept that. I'm just saying that you don't want to have a legal clog on the sharing of information. That's all I'm saying.
Yeah, I hear you on that. it's something I want to tread very carefully on. Yeah, tread very carefully on. Those are the points I just wanted to respond to. Yeah, I wanted to respond to, Madam Speaker, and we will suspend the debate and hope to conclude next week.
Members, the question is that the debate be suspended until the next sitting of the House. Those in favor? Those against? The ayes have it. Minister, may I now invite you to do the
Madam Speaker,
microcredit?
I now move for the suspension of the standing orders to enable me to take the motion, notice of which I gave earlier.
Microcredit bill. Madam Clerk? Those in favor? Those against? The ayes have it.
No. Madam Speaker, I stand here to commence debate on the Act to license and regulate microcredit institutions that provide financing to individuals, to micro, small, and medium-sized enterprises, and for connected matters, shortly entitled the Microcredit Act 2021. Madam Speaker, the government of Prime Minister Andrew Holness has made the improvement of access to finance a central policy axis in the last administration and in this one. We capitalized the central bank to give the BOJ the capacity to use open market operations to manage liquidity rather than rely on prudential reserve requirements. And among other factors, this has allowed the BOJ to reduce reserve requirements, bringing interest rates down. We abolished ad valorem stamp duty on financial transactions, making it easier for customers to switch providers, promoting competition and lowering rates. Yes. We reformed the pension investment limits to allow pension funds to invest in venture capital, private equity, and private securities. We slashed fees charged by the FSC to the Jamaica Stock Exchange to allow for a private market in bond securities to be developed. Today, Madam Speaker, we introduced major legislation to improve access to finance for low-income households, for MSMEs, for those in the informal sector, and those who rely on microcredit institutions. Madam Speaker, greater access to finance is an important development imperative, particularly for low-income households, for MSMEs, who are generally underserved by commercial banks. The rapid expansion of the microcredit industry in Jamaica has introduced opportunity for many low-income households and micro and small businesses and informally employed individuals to become integrated into the financial system. Notwithstanding this, Madam Speaker, the proliferation of the microcredit industry has presented certain challenges, ranging from predatory lending practices and other consumer-related issues to the need to ensure that these institutions are not used to facilitate money laundering and terrorist financing. These concerns prompted the government to develop a more effective regulatory framework that is designed to facilitate the growth of microcredit institutions, promote greater access to financial services by low-income groups, and at the same time protect the rights of consumers and the integrity of the financial system. Madam Speaker, this bill to enact the Microcredit Act seeks to, among other things, one, license and regulate microcredit institutions that provide financing to individuals, micro, small, and medium-sized enterprises. Two, to discourage microcredit institutions from lending money at excessive interest rates that are not justified by the risk. Let me say it again. To discourage microcredit institutions from lending money at excessive interest rates that are not justified by the risk. Madam Speaker, the bill seeks to outlaw, to make illegal, predatory lending practices. threats and intimidation that are sometimes part of the micro-lending business in Jamaica. Madam Speaker, the bill seeks to promote greater transparency and the disclosure of pricing and terms of product that offer greater consumer protection. The bill seeks to reduce the risk of the industry being misused to facilitate money laundering. In addition, Madam Speaker, the proposed Microcredit Act is important as it is expected to facilitate the provision of sustainable microcredit for informal MSMEs and is in keeping with the government's thrust to accelerate economic growth and to create jobs for Jamaicans by, among other things, expanding access to credit to MSMEs, which are the engine of Jamaica's economy. Madam Speaker, the enactment of this bill is also timely in light of recent developments pertaining to the issue of de-risking and the resultant closure of bank accounts of some microcredit institutions by commercial banks, which has implications for the microcredit industry. This has underscored and made even more urgent the need to formalize the microcredit industry through licensing and regulation. The passage of the microcredit bill at this time is also critical as it is one of the time-bound priority legislative reforms necessary for Jamaica to remain in compliance with the Financial Action Task Force and the Caribbean Action Task Force procedures required to improve our money laundering, anti-money laundering and combating terrorism regime. It is imperative for the enactment of the Microcredit Act by the end of January 2021, which will allow microcredit institutions to be brought under the regulatory framework of the Proceeds of Crime Act, the Terrorism Prevention Act, and to be subject to AML CFT regulations. Madam Speaker, as you and members of this Honourable House may recall, the Microcredit Bill was previously tabled in this House in February of 2019. Subsequent to that tabling, the microcredit industry raised several concerns about the bill during consultations. The bill has been through several rounds of consultation and has been revised to take into account the feedback and recommendations of key stakeholders, including the Jamaica Microfinancing Association and the Jamaica Association for Microfinancing, two separate membership associations in the microcredit sector. Madam Speaker, I would like to thank the staff from the Ministry of Finance and the Public Service, the Bank of Jamaica, the Attorney General's Chambers, and the Office of the Chief Parliamentary Counsel who provided the technical services and input in the drafting of this bill. Madam Speaker, I'd like to go through, yes, please give them applause, please. Madam Speaker, I now will go through the main provisions of the bill, clause by clause, and, we're talking about over 60 clauses. Part 1, Madam Speaker, deals with the preliminary matters and sets out the definition of the terms and the scope of the Microcredit Act. Clause 1 states a short title and commencement and addresses preliminary issues such as the name of the bill. Clause 2, subsection 1, Madam Speaker, the interpretation. This clause sets out the definition of terms used in the bill, including definitions for important services such as microcredit institution and microcredit service as follows. Microcredit institution means a company that is licensed under this Act to provide a microcredit service to individuals or MSMEs or both. Microcredit service means any one or more of the following services provided by a microcredit institution. The granting of credit facilities to individuals or MSMEs or both. And 2, the provision of business advisory services, not including the advice relating to the financial services regulated by the Financial Services Commission, to individuals or MSMEs or both. Or B, any other activity designated by the supervisor as a microcredit service and approved by the minister by order, subject to affirmative resolution, but does not include receiving deposits from the public or banking business within the meaning of the Banking Services Act. Clause 2, subsection 2 outlines the fit and proper requirements for the shareholders and officers of a licensee. The fit and proper criteria include information such as the background, competence, honesty, and integrity of the owners, directors, and senior management of a microcredit institution. Clause 3, non-application of the Act. This clause makes provision for the transactions, persons, and entities that will not be covered by the Microcredit Act. The circumstances where the Act will not be applicable are listed in the third schedule and include financial institutions that are regulated by the Bank of Jamaica, the Financial Services Commission, or other regulatory bodies, as well as credit facilities offered to high net worth individuals. And there's another exclusion that I hope to introduce by way of amendment, and that is to exclude the provision of credit by employers to employees from falling under the definition of a microcredit service. Part 2 of the Act deals with the functions of the regulatory authority and other matters as follows. Clause 4, the functions of the regulatory authority. This clause provides for the functions of the regulatory authority, which is proposed to be the Bank of Jamaica. The functions of the regulatory authority will be executed through the supervisor and supervisory department and include formulating procedures for the licensing and regulation of microcredit institutions, developing standards of practice and codes of conduct and guidance for the general operations of licensees, including credit administration, transparent lending practices, and reporting requirements. It also deals with the monitoring of licensees on an ongoing basis by off-site and on-site examination for compliance with the Act based on the risk profile of the licensees. And that's important because at the moment there are over 200 of these entities, and so they have to be dealt with on a risk-adjusted basis. 3, prescribing the types of returns and other information that licensees are required to file with the supervisor. 4, advising the minister on matters of general policy. And 5, imposing sanctions for the identified breaches of the provisions of the Act and regulations. The regulatory authority is also required to submit to Parliament through the Minister an annual report relating to the execution of its function. Clause 7, cooperation of regulatory authority with other regulators and the Commission. This clause makes provision for cooperation and collaboration between the regulatory authority with other regulators, both local and foreign law enforcement authorities and other regulatory counterparts to facilitate information sharing and other forms of cooperation and collaboration. This clause also expressly makes provision for cooperation and collaboration between the regulatory authority and the Consumer Affairs Commission in relation to the investigation of any apparent contravention of the Act. Based on the subject matter of the complaint, either body may refer a complaint as appropriate. Now, Mr. Speaker, this is I'll get to it later. Part 3 deals with the licensing and regulation of microcredit institutions as follows. Clause 9 prohibits against operating a microcredit institution without first obtaining the requisite license to provide a microcredit service. It also makes the provision of a contract for the provision of a microcredit service by a person who is not licensed to be unenforceable. Madam Speaker, that is very important, that if you are not licensed as a microcredit institution, you enter into a contract for the provision of microcredit services, that contract is unenforceable without having the requisite license. Clause 10 deals with the application for and grant of a license, sets out the procedure for obtaining the license. The applicant is required to apply to the supervisor in accordance with the prescribed rules made under the Act. The clause also makes provision for the supervisor to grant or refuse to grant a license to the applicant. Further, where the applicant is refused a license, the applicant is given the opportunity to be heard by the supervisor. Clause 11, conditions of license, requires the licensee to pay a prescribed license fee to the Accountant General on the initial grant of the license and thereafter annually. Also, the licensee is required to commence operation within 1 year of the grant of the license or such longer period as allowed. Clause 12 mandates that a licensee should prominently display its license at its principal office and at each branch. Clause 13 prohibits a licensee from transferring or assigning its license. It also prohibits a licensee from causing or permitting another person to use its license. Where the licensee causes or permits another person to use its license, the supervisor may suspend the license. Clause 14 sets out the procedure for the replacement of a license that becomes lost, defaced, or destroyed. The licensee will be required to pay a replacement fee to the Accountant General for a substitute license. Clause 15 criminalizes obtaining a license by false representation. Clause 16 criminalizes engaging in false or misleading advertising that falsely implies or explicitly states that the person is licensed under the Act as a microcredit institution. Clause 17 on the prohibition on the use of certain names and titles is intended to address the mischief of the use of words or titles that represent or imply that a person is licensed to operate as a microcredit institution when in fact it is not. It is not intended to disenfranchise genuine cases, i.e. bodies established to represent the interests of the sector, but accordingly, Clause 7 prohibits a person who is not licensed under the Act from using any name, title, word that implies that it is licensed to provide microcredit service except with the approval of the supervisor, or if it is an association representing microcredit institutions, or where it forms part of the name of an individual or a place. Clause 18 on the regulation of mergers, amalgamations, acquisitions, and transfers requires a microcredit institution to obtain approval from the regulatory authority for changes in its corporate structure, such as a merger, amalgamation, acquisition, and transfer. The application should be in the form of a scheme. A merger, amalgamation, acquisition, or transfer which is effected without the approval of the supervisor shall be void. Clause 19, regulation of shareholding in microcredit institutions. This provision addresses transactions or arrangements that have the effect of changing the effective control or substantial ownership of the licensee. Accordingly, Clause 19 requires a person who proposes to enter into an agreement or an arrangement to acquire the shares of a licensee and who would become a substantial shareholder of the licensee to obtain the prior approval of the regulatory authority in respect of the agreement or arrangement. In determining whether or not to approve an application, the supervisor shall take into account matters such as 1. The nature, source, and sufficiency of the applicant's financial resources, 2. The business record and experience of the applicant, and 3. Whether the applicant meets the fit and proper criteria. An acquisition of shares effected in contravention of this section is void. The clause also specifies the circumstance and actions that can be taken in respect of the shares acquired in contravention of the section. Clause 21, duty of licensee to notify supervisor of fraud or dismissal. This clause imposes an obligation on a licensee to notify the supervisor of matters that could adversely impact it, such as any fraud or other criminal activity committed by or against a licensee, or any dismissal or resignation of an officer, or any circumstance which renders a substantial shareholder or officer of the licensee incapable of satisfying the requirements of a fit and proper person, or any acquisition of 10% or more of the issued voting share capital of a licensee, or if proceedings for compulsory winding up of the licensee have commenced or the licensee has been served with notice for the commencement of compulsory winding up of its business. Clause 22 imposes a restriction on a licensee making an alteration to any of its incorporating documents unless it notifies the supervisor and the supervisor does not object. Any alteration made to the incorporation documents of the licensee that is incorporated in Jamaica in contravention to the section shall be void. Clause 23 imposes a restriction on a licensee changing its registered name unless it notifies the supervisor and the supervisor has no objection to the change. The supervisor shall reissue the license in the new registered name of the licensee once the licensee satisfies the conditions, including surrendering the existing license and paying the prescribed fee to the Accountant General. Clause 24, duty to supply information and documents, allows an authorized officer at all reasonable times and may be reasonably be required for the performance of its functions to have access to all documents in the possession and control of the licensee, and where applicable, take copies of such documents. Also, Clause 24 requires any officer, employee, or external auditor of the licensee to furnish such information or to produce such documents as are in the possession or control that relate to the operations of the licensee. Clause 25 on supervisory measures outlines the range of measures that the supervisor may employ for breaches of the provisions of the Act, including issuing a warning to the licensee, or directing the licensee to cease such practices, or directing the licensee to take corrective action, or the suspension or revocation of the license. Clause 26 sets out the circumstances for suspension of a license, including that the licensee intends to suspend microcredit service for a period, or a substantial shareholder or officer has been charged with an offense involving fraud or dishonesty, or the licensee is contravening the Act or regulations by engaging in activity which does not constitute a microcredit service without instituting the differentiated mechanisms referred to in Section 31, or the entity failing to keep accurate records in respect of the microcredit business, or failing or refusing to file the requisite returns, or causing or permitting another person to use its license, or breaching a supervisory direction. The circumstances for revocation of a license are set out in Clause 27 and include that the licensee has operated or is operating in breach of its incorporating documents, or that the licensee has breached or is breaching a term or condition of its license, or that the licensee has failed to commence operations within the period specified in its license, or that proceedings have commenced for the voluntary or compulsory winding up of the licensee, or that the licensee has ceased to be viable. The licensee shall be given an opportunity to be heard or to make an objection to the supervisor in relation to the suspension or revocation of a license within a specified time frame. The clause also gives the supervisor discretion that where the supervisor intends to suspend or revoke a license, the supervisor may take such action as is necessary to safeguard the security and confidentiality of the credit and other personal information and documents in the possession and under the control of the licensee. Part 4 deals with the issue of governance of licensees as follows. Clause 28 to 30 are intended to ensure that licensees are subject to good governance principles as follows. Clause 28 deals with the requirement for the licensee to have a board of directors with the requisite knowledge and skills and expertise. Clause 29 deals with the responsibilities of the board of directors for the effective governance of the microcredit institution. Clause 30 deals with the duty of the licensee to ensure that each substantial shareholder and officer remains a fit and proper person. Clause 5 deals with Part 5 of the Act of the bill deals with limitation on business activities of licensees and obligations of licensees as follows. Clause 31 deals with the microcredit services not to be commingled with other business activities. The bill that was tabled in February 2019 restricted microcredit institutions to only engage in the provision of a microcredit service. However, based on concerns raised by the industry during consultations, Clause 31 has been revised to remove this restriction and allow microcredit institutions to operate other businesses, providing that it institute measures to clearly differentiate its microcredit business from its other business activities, including keeping separate bank accounts for the microcredit part of its business and maintaining separate accounting procedures and accounting records for the microcredit component of its business, or for the microcredit institution, as defined. Clause 32 on foreign currency transaction prohibits any dealings by a licensee in a foreign currency unless the requisite authorization is obtained in accordance with the Bank of Jamaica Act. Clause 33 on the obligation of confidentiality requires every officer, employee, auditor, or agent of a microcredit institution to treat information and documents pertaining to its customers in the performance of their duties as confidential. This obligation extends beyond termination of duty or employment with the licensee. Also, persons are expected to treat all information received as confidential. The bill also specifies the circumstances under which information can be disclosed, including with the written consent of the borrower and/or pursuant to a court order, etc. Clause 34 deals with the records to be kept by the licensee. This clause requires microcredit institutions to maintain proper records for at least 7 years. The clause also requires microcredit institutions to furnish their records in the prescribed form and manner. Clause 35 accounts and audits and appointment of external auditors. The clause requires a licensee to be audited annually by an external auditor who is a registered public accountant. However, where a licensee meets the description of a small company under the Companies Act, it shall have its accounts prepared pursuant to the Companies Act by an external auditor who is a registered public accountant. Clause 38, presentation of financial statements. The bill that was tabled in February 2019 required microcredit institutions, in accordance with Section 35, to submit audited financial statements or accounts prepared pursuant to the Companies Act within 90 days of the financial year. Consequent on concerns raised by the industry, the bill was revised to increase the timeline to 120 days. Part 6 deals with appeals to the Microcredit Appeals Tribunal. Importantly, Madam Speaker, the Act or the bill envisions the opportunity to appeal decisions of the supervisor with the installation of a supervisory appeals board that is analogous and similar to the supervisory appeals board under the Banking Services Act. The bill that was tabled in February 2019 made provision for an aggrieved person to appeal to the supervisory appeals board under the Banking Services Act in relation to fit and proper and appointment of external auditor and revocation of a license. Based on concerns raised by stakeholders during consultation, Clause 41 has been revised to remove altogether the provisions relating to the appealing the supervisory determinations, since it poses a challenge to how the regulator would effectively supervise entities. It should be noted, however, that persons would still have the right to appeal using the courts. In addition, Clause 41 has been revised to replace the Supervisory Appeal Board with a specially established Microcredit Appeals Tribunal, i.e., we first envisioned that we'd use the same, for the sake of not having the bureaucracy be expanded, having the same Supervisory Appeals Board that deals with banks to deal with appeals here. In consultations, we have scrapped that and are setting up a specific Microcredit Appeals Tribunal to hear appeals brought by licensees in respect of decisions made by the supervisor. The constitution and procedures of the Microcredit Appeals Tribunal are addressed in the second schedule. Now, Part 7, Madam Speaker, deals with protection of consumers, and it's very important and critically important. Madam Speaker, it should be noted that the Consumer Affairs Commission will be responsible for market conduct matters, particularly where a complaint involves the matter of consumer protection, which ordinarily requires powers to, among other things, assess and determine on the fairness of contract terms and to impose obligations or take actions designed to provide redress to the aggrieved consumer, as these are not powers that exist within the Bank of Jamaica. However, Madam Speaker, where a complaint involves the matter of a licensee breaching its statutory obligations or breaching a requirement of the framework, the imposition of regulatory sanctions is a response that can be made by the Bank of Jamaica. To avoid an overlap in responsibilities, provision is included in the Act to ensure the cooperation and collaboration between the Commission and the regulatory authority, including the referral of matters to each other where appropriate. Clause 42, power of the Commission, empowers the Consumer Affairs Commission to investigate complaints brought to it by a consumer of a microcredit service. Clause 43 on loan agreements specifies that where the licensee grants a loan, the licensee shall provide a copy of the loan agreement to the customer, and the loan agreement should include information such as the particulars of the parties involved, the date the loan is made and dispersed, the amount of the loan and the terms of its repayment, including the full disclosure of the cost of the loan expressed in both percentage rate of interest and dollar value terms, security for the loan required, fees and charges, if any, and a fact sheet containing the key terms of the loan agreement. So, Madam Speaker, you go to a microcredit service as an individual who is in need, or as a smaller microcredit business, the days of providing the provision of that loan with the terms being opaque and not clear, with the interest rate not being clear to the applicant or even how the interest is applied, with the fees and charges not being clear, those days are over. The bill will specifically require disclosure to the borrower of all the particulars of the loan, including all of the financial terms. And this, Madam Speaker, will promote transparency through the requirement that there must be full disclosure to clients of all terms and conditions requiring the services. Now, there's a clause later, but I want to refer to it here. Very importantly, Madam Speaker, people borrow from microcredit institutions today, and interest rates are quoted in monthly or weekly terms. 3% a week, 2% a week. And it sounds cheap to the persons who are not informed, because the number 3 is a low number. But if the number 3 is applied every week or is applied every month, the annual rate becomes very high. Now, Madam Speaker, the bill provides for market forces to prevail, and there's a risk associated with the business, and entities are entitled in a market way to try and recoup because of the risk that's being taken. However, they must do so with the full information being provided to the borrower. So this bill, for the first time in Jamaica, Madam Speaker, will require that the microcredit institution provides the rate of interest in an annualized basis. So the person who is borrowing will be able to compare. If I'm able to borrow from a bank, the rate is so. If I borrow from a building society, it is so. If I borrow from a microcredit, it is at this level, and they can make an informed decision. Madam Speaker, markets that operate without information are markets that become oppressive. And this government, Madam Speaker, is for regulation of the sector, and we want the businesses to thrive, but we also stand with the people who are customers of these institutions to ensure that they are protected. Madam Speaker, Clause 44 requires the licensee to provide a printed copy of a statement of accounts at the request of the borrower or at the option of the borrower in electronic form. It also stipulates that the licensee shall issue a receipt or confirmation of the repayment of the loan to the borrower on the repayment of the loan. So there's a paper trail that the borrower can have. You can't come after them 2 years later and say you still owe the money. Clause 45 imposes an obligation on the borrower to provide evidence of the ability to repay the loan. This will encourage responsible lending and reduce the risk of over-indebtedness of borrowers. So the borrower should furnish, this business of just turning a blind eye and wanting to be able to get the 5% a week. Right? The borrower needs to establish that they can repay at the rates being quoted. The bill, Madam Speaker, that was tabled in February required microcredit institutions to determine its interest rate by taking into consideration cost of funds, profit margins, borrower's credit risk, admin costs, and other loan-related costs. The industry strongly opposed the approach during consultations, and as such, the government listened, and the bill has been revised to allow for flexibility in the determination of rates to be charged by microcredit institutions, but with the provision that there is full information. And so individuals and customers with over 200 institutions in place can make informed decisions as to where they want to seek financing. Accordingly, Clause 46 has been revised to allow microcredit institutions to determine their interest rates based on market forces and on their own risk assessment. What I alluded to earlier, Madam Speaker, is found in Clause 46, which requires microcredit institutions to provide their customers with information on the effective annual interest rate. That is the interest rate that covers all financial costs, such as interest rates, fees, commissions, expressed as a percentage of the loan. So you might charge 5% a week, but you might also charge a loan processing fee of $20,000. What the law requires you to do now is to take all of the interest costs, to take all of the fees and commissions, and to take it as a fraction of the loan and apply the formula that is in the bill and express it as an annual effective interest rate. This is expected to facilitate greater transparency as consumers will be able to comparison shop for loans, thus stimulating competition among microcredit institutions. The methodology for determining the effective annual interest rate is found in the first schedule. Very importantly, Madam Speaker, Clause 48 on complaints sets out the procedures for the making and resolving of consumer-related complaints related to consumer protection under the Microcredit Act and the responsibilities and powers of the Consumer Affairs Commission in investigating and solving such complaints. So the Act specifically provides an avenue that does not exist today for consumers of microcredit institutions to complain to regulatory authorities about market conduct, market misconduct, or for breach of the microcredit institution fulfilling and living up to the terms of its licensees. Madam Speaker, Code of Conduct in Clause 49 is intended to establish minimum standards of good practice required by licensees towards their customers. So accordingly, Clause 49 makes provision for the Consumer Affairs Commission, with the approval of the Minister, to make and issue a code of conduct for microcredit institutions on consumer-related matters. Further, the Commission is empowered to issue directions to a licensee who contravenes the code of conduct. So it does not stop here. It does not stop here with the bill. The Consumer Affairs Commission is empowered with this Act to put in place a code of conduct. And that Consumer Affairs Commission, right, lies with you. A code of conduct that will guide how microcredit institutions ought to operate. It's analogous to the code of conduct that the BOJ has developed in the banking sector. And the code of conduct promotes fair treatment of the consumer of the licensee and places an obligation on microcredit institutions to present the loan agreement in plain and simple language that's understood by clients. Clause 50, enforcement measures of the Commission, empowers the Commission with the requisite enforcement powers to effectively execute its functions under the Microcredit Act. Clause 51 prohibits false or misleading advertisement by the licensee in relation to the grant of a loan. Clause 52 prohibits false deceptive information to induce a person to take a loan from microcredit institution. Clause 53, Madam Speaker, critically important, on threatening. The bill that was tabled in February 2019 provided for the criminalization of a person who, in an attempt to recover a debt, displays or causes to be displayed any or uses any threatening or abusive or harassing or intimidating words or behavior, writing or signs or visible representation. But that was too broad. But we have kept the spirit, Madam Speaker, and the bill has been revised to restrict its application to the use of only violence or other criminal means to harm the physical person or the property of the person, since there are pieces of legislation, including the Cybercrimes Act, which addresses some of the other issues. So the use or threatening the use of violence in the collection of loans given by microcredit institutions is criminalized by this bill. Part 8, Madam Speaker, deals with the voluntary and compulsory winding up of a licensee as follows. Clause 54 sets out the procedure for the voluntary and compulsory winding up of a licensee. In general, winding up of a licensee shall be subject to the Insolvency Act unless the licensee is a part of a financial group under the Banking Services Act, in which case the Insolvency Act will only apply to the winding up of that licensee with the written consent of the supervisor. Part 9 deals with general matters as follows. Clause 56, fixed penalties. This clause makes provisions for the persons who commit less egregious offences to discharge liabilities to conviction of such offence by payment of a fixed penalty. The offence and penalties are detailed in the 5th schedule. So the idea is not to criminalize persons who are trying to be in business and provide a business service, unless they fail to pay the penalty. So much like your traffic ticket, you don't observe the code and you're issued a ticket, that does not become a criminal sanction or penalty unless you refuse to pay the traffic ticket. So there are a number of infringements of the bill for which a fine would be levied. And if the fine is not paid in the requisite time period, then the sanction becomes a criminal one. Clause 57, Search Warrant for Contraventions Act, allows an authorized officer under specified conditions to apply to a justice of the peace for a warrant to enter and search the premises of a person who is suspected of committing an offence under the Act. The authorized officer is also empowered to seize and detain any relevant document which is relevant to the investigation. Part 10 deals with miscellaneous matters as follows. Clause 58 empowers a regulatory authority with the approval of the minister in writing to make regulations for giving effect to the Microcredit Act in relation to the requirements for the grant of a license under the Act, license fees and other matters in respect of which fees are to be payable and the amount of such fees, mergers, amalgamations, acquisitions and transfers involving licensees and the sale of a license, and the establishment of a branch of a licensee. The regulations made under this clause shall be subject to affirmative resolution. Clause 59, Madam Speaker, empowers the regulatory authority with the approval of the minister to make rules for the operation of microcredit institutions in relation to the governance of licensees, the form of applications and notices, and anti-money laundering, counter-financing of terrorism, and the prevention of the proliferation of weapons of mass destruction, and the preparation and presentation of returns and other reporting requirements, and the manner of filing such returns and other information. The rules shall be subject to affirmative resolution. Clause 51 on immunity provides statutory protection for authorized officers of the BOJ exercising their function in good faith. Statutory protection extends to the officers of the Consumer Affairs Commission. Clause 62, review of the Act. This clause makes provision for a review of the Act to be conducted no later than 5 years after the commencement date by a committee of both Houses of Parliament appointed for the purpose. Importantly, this provision will facilitate the collection of much-needed data on the industry that could enhance the regulation of the microcredit institution. Clause 64, a transitional clause. This clause provides for a person who, at the commencement date of the Act, is operating a business which falls within the criteria set out in the Act for a microcredit institution to within 12 months from the commencement date to apply to the supervisor for a license to operate under the Act. So, Madam Speaker, for businesses involved in the provision of a microcredit service today, this represents a big change, and a big change in the interest, in the public interest, and in the interest of Jamaica in multiple ways that I have outlined previously. The Act envisioned that the compliance cannot occur overnight, and it gives licensees and operators of microcredit institutions 12 months from the appointment date to apply to the regulatory authority and to be licensed. And, Madam Speaker, and in addition, a person who at the commencement date is operating a business which falls within the criteria set out in the Act for a microcredit institution, together with another type of business, shall have 12 months from the commencement date to separate the businesses and to apply to the supervisor for a license to continue to operate its business as a microcredit business under the Act. Clause 65 on savings provides...
Minister, your time for speaking has expired.
Madam Speaker, I ask for Minister to be allowed time to complete his presentation.
How much time is the Minister considering? $10 minutes?
Or less.
10
the
minutes?
question before the House is that the Minister be allowed an additional 10 minutes to complete his presentation. Those in favor? Those against? The ayes have it. Minister, your turn.
Clause 65 provides for the preservation of money lending transactions which were entered into before the commencement date of the Act to continue to be enforceable after the commencement date. The first schedule, Madam Speaker, is divided into two parts. Part A deals with the methodology for determining the effective annual interest rate that I spoke to earlier. Part B provides for the categorization of MSMEs based on the MSME and entrepreneurship policy tailored for the purposes of the Act. Accordingly, MSMEs will be defined solely in terms of the total annual sales of the enterprise. And the annual sales in the Act is consistent with the definition in the MICAF, or the Ministry of Industry, Investment and Commerce, who define MSMEs. The second schedule provides for the constitution and procedures of the Microcredit Appeals Tribunal. The third schedule is divided into two parts. Part A deals with the list of transactions, persons and entities not regulated by the Act. Part B stipulates that the provision of a credit facility to a high net worth individual will not constitute a microcredit service, and as such would provide for high net worth individuals to be would provide for credit extended to high net worth individuals to be exempt from the Act. The fourth schedule lists the offences and penalties relating to the contraventions of provisions of the Act. The fifth schedule lists offences in respect of which liability to conviction may be discharged by the payment of a fixed penalty. The sixth schedule lists consequential amendments to various acts, including the Credit Reporting Act, the Money Lending Act, the Proceeds of Crime Act, the Terrorism Prevention Act, and the United Nations Security Council Resolutions Implementation Act. The amendment of the POCA and the Terrorism Prevention Act will ensure that licensed microcredit institutions under the Microcredit Act are recognized as financial institutions. This will, in effect, subject the microcredit institutions to the AML-CFT requirements under the POCA and the TPA. It is important to note that the Money Lending Act will continue to exist and will apply to unregulated loans offered on a non-commercial basis, such as money lending transactions between persons who do not lend on a day-to-day basis to the public or to persons who lend incidentally to their main business. Finally, Madam Speaker, the Memorandum of Objects and Reasons explains the purpose of the bill and provides an overview of the necessity and scope of the bill. Among other things, it states that the bill seeks to regulate the provision of microcredit services offered by microcredit institutions in order to ensure that A, microcredit services may be utilized by micro, small, and medium-sized enterprises and individuals to facilitate their financial or economic advancement. B, the sustainable growth of micro, small, and medium-sized enterprises may be facilitated. And C, a transparent, fair, and competitive landscape is created for microcredit institutions, which will minimize asymmetric information and promote best practices. And D, microcredit institutions are not used to facilitate money laundering activities and the financing of terrorist activities. Madam Speaker, I commend the Microcredit Act 2021 to this Honourable House for approval.
Cheers. Madam Speaker, thank you. Madam Speaker, this bill was tabled last week, Tuesday. And because of Jamaica's prejudicial standing in relation to our legal and institutional framework for fighting terrorism financing and money laundering, the government has a sword over its head, so to speak, to pass this in January, so that the minister has indicated to the opposition that this bill has to pass the House today. It's an unsatisfactory state of affairs, to say the least, because this is not a short or simple matter. This is a bill with 65 clauses, some of them very long, 6 schedules, an 88-page document of statutory legalese. Furthermore, it is not like this bill has had a happy history. It was tabled in 2019, never debated, because there was an uproar from the industry because of what was then regarded as the excessively penal nature of that bill. A process, as the minister has outlined, of redeveloping the bill and some amount of toing and froing with the industry associations has ensued. The opposition saw this for the first time on Tuesday. My understanding is that there are still strong concerns within the industry about the bill. So really, given the constraints that the minister is working under and having to pass this because of some foreign pressure in January, it's a pity that this couldn't have been tabled sometime before. And I think it's reflective to me of an inefficient management of the legislative process, that we allowed it to get to the point where a bill is being tabled, of this nature is being tabled 1 week and has to be passed the following week. There are persons who would have liked to have had a chance to speak to it, but for one reason or another, the week was not sufficient time for them to do so. I went through the bill myself today before coming. I did not have a chance to speak to anybody from the industry about it. They had consulted with me when the original bill was tabled. I had written a brief memo on why I thought it was a bad bill, and I noted that bill didn't go forward. And nearly 2 years later, this is what is being presented now. The minister has heralded it in glowing terms. Speaking for myself, having read it, there are some things in it which are good, but its overall approach I do not think is developmental for the financial industry, in particular the microfinance industry. It still remains a very penal statute. I think it has 34 new criminal offenses created by it for what are often administrative failures. And so microfinance practitioners can find themselves before the criminal courts for matters which are really, I would say, administrative in nature. And I think that's the wrong approach to the matter. I don't see anything in here that will enhance the fortunes of the microfinance sector, a sector which has been a dynamic, growing sector. There are 2 industry associations now for that sector, and many entities that are participating in the industry, and they have provided access to credit for people who would not otherwise be able to get credit. That is the reality of it. The banking sector has largely left that segment of the market untouched up until recent times. In more recent times, they have now started to try to get into it because they see it as a lucrative opportunity. But the micro sector was built by the firms that are now there, and there's a proliferation of them. So I am concerned, A, about the process that we're following here in rushing this through Parliament, and B, with the approach taken by the bill, which, as I've said, while it has some features in it which I agree with, also has others which I think are officious and penal in nature. And overall, I don't think this bill is going to benefit the microfinance industry. And I think to the extent that it has a chilling effect on new entrants or existing participants, it is not going to help the cause of financial inclusion. And it will not help the cause of further investment in that sector either. I will now move to a more specific commentary on aspects of the bill, having given that brief overview. An important point which I think needs to be clarified in this is whether or not loans to companies are caught by the Act or are exempt from the Act. There's a schedule which specifies who are exempt from the provisions of the Act. It's a scope section, or a schedule that deals with scope, and it provides language which has been used in other statutes and which is interpreted. I'm not saying it's ever been ruled on by a court. I'm not aware of that if it has been, but it is interpreted in the industry as having the effect that loans to companies are excluded. It's item 10 of the third schedule, Part A. Third schedule, Part A says that this act shall not apply to the following, and it has a long list of 16 categories of persons who this does not apply to. And item 10 says, any loan to or contract to security for the payment of money lent to a body corporate incorporated in Jamaica by or under any enactment or royal charter. That language is apt to cover companies incorporated under the Companies Act. if that is the intent, I have no problem with it. But then I noticed that in the definition of what a microcredit institution is, it speaks to a company that's licensed under this Act to provide microcredit service to individuals or MSMEs, or both. That wording suggests that it would apply to some category of entity that is not an individual, but falls within the definition of an MSME. An MSME is an enterprise that has a certain level of turnover or sales, and they're from micro to small to medium, and it's set out in the Act what those categories are. But it's not specific as to the nature of the entity or enterprise. And the language here would suggest that it would apply to some entity that has a legal construct other than being an individual. And that makes me unclear as to the scope of the legislation in a very fundamental area. On page, I just want to make one general point as well. The banks, the commercial banks, as I've said, have recently, in recent times, started to come into this segment of the market and have tried to compete with the microfinance institutions. There are provisions in this legislation that will apply to microfinance lending, but will not apply to bank lending. This creates an asymmetry in that segment of the market on issues of disclosure, how the interest rates are calculated, how the interest rates are capped, all aspects of this legislation has a strong consumer protection slant to it, which does not apply to banks that are operating in the same economic space. And I think that's bad policy and needs to be reconsidered. I noticed that the definition of microcredit service, which is an important definition in the Act, because it's used as a tool for many provisions in it. The definition talks about, well, it reads as follows. Microcredit service means any one or more of the following services provided by a microcredit institution. Now, microcredit institution is also a defined term, and it's defined as a company that is licensed under the Act. Now, the effect of this is that if you're not licensed under the Act, you're not a microcredit institution. And if you're not a microcredit institution, then you're not providing a microcredit service by definition. This seems to create a huge loophole in the Act, because it means unlicensed entities are not deemed by definitions to be providing microcredit services. And this is seeking to regulate microcredit services. So it cannot be that unlicensed entities escape from the ambit of the Act. That needs to be considered. I move to page 13 of the bill, and I'm going off of the long form that was tabled, not the short form that was handed out today, the printed version. I'm going off the original long form that was tabled last week, because that's what I had to review. This deals with clause 6. And I noticed that it's talking about whether, in what circumstances authorized officers or other persons authorized to assist an authorized officer can disclose information regarding the operations of a licensee. There's no provision in here for a court order as being one of the grounds on which this information can be disclosed, and I think there ought to be. It does say disclose, it says shall not disclose other than for purposes of the investigation of a financial crime, which is paragraph C in 6.1. But it doesn't say investigation or prosecution. And the disclosure would obviously, most importantly, be in the form of evidence given in a criminal trial. I think that ought to be subsumed in the language here. shouldn't be limited to investigations, but should include prosecution. And it should, I think also, court orders should be specifically mentioned. I move to page 14 of the bill, and this is clause 9. This is a vital provision because this is a provision that supposedly criminalizes non-compliance with the legislation in the form of operating without a license. But its wording is peculiar. Rather than saying a person shall not provide microcredit services unless they are licensed in accordance with this act and make it a prohibition, it says a person who desires to provide a microcredit service shall be licensed as a microcredit institution under this act. The wording of that, depending on how you interpret it, would almost suggest if you desire to provide that service, you shall be licensed, which is obviously not what is intended. What is intended is to say that if you cannot provide that, you can't go into this business of microfinance service providing without being licensed. I don't know why it's worded like that. That is not the way it's worded in, for example, in the banking legislation in relation to taking deposits, or in the securities legislation in relation to dealing in securities or giving investment advice. It's worded as a prohibition rather than in this positive formulation. I'd also suggest to you that that ought to be subject to Section 64, which is a transitional provision, because there are all existing players in this industry are going to be providing microcredit services for up to a year without being licensed in this act. So the 9.1 ought to make reference to the transitional provision as an exemption from the ambit of 9.1. Minister, you spoke to the 9.3 and talked about the benefit of this particular provision. This is a provision that says that a contract for the provision of a microcredit service shall be unenforceable if the contract is entered into by a person who is offering a microcredit service but has not obtained a license. I must tell you from my perspective as a practitioner in this field for my entire career as a lawyer, I do not recommend going down the route of invalidating financial transactions. Invalidating a financial transaction which has occurred has all kinds of consequences. For one, it creates a windfall undeserved by the other party to the transaction because the loan cannot be enforced against them. So they can keep the money and not repay it. So effectively it becomes a gift, gifted to them by the statute. It creates a huge incentive to take legal points about the enforceability of these contracts. It's really a rogue's charter. I don't think it's a good idea. I don't think it's necessary either, because the entire scheme of this is to criminalize all sorts of aspects of conduct around microfinance lending and microcredit services. And making the contract illegal just creates a whole range of legal risks and legal pitfalls which are undesirable. I don't personally think you should go down that route. I mean, I note, for example, in the Banking Services Act, transactions which are in breach of the restrictions on what banks can do are not made illegal. Their legality is in fact preserved, even though there may be regulatory violations involved for which the licensees may be punished or subject to sanction. But the transactions themselves are not impugned. I think that's the right way to go. I turn to page 30 of the bill. This is dealing with supervisory measures. It says where the supervisor is of the opinion that a licensee has contravened or is contravening a provision of this Act. It's page 30, and it's clause 25.1. Where the supervisor is of the opinion that a licensee has contravened or is contravening a provision of this Act, etc., the supervisor may do any one or more of the following. And words that I didn't read are the important ones. It's contravening a provision of this Act or any other enactment under which it has an obligation, or a direction, rule, order, requirement, or standard made or imposed thereunder. And then what follows is the capacity to issue a warning, issue directions, suspend, or revoke. I would have thought that included in that ought to be contravening a condition of your license, or contravening a condition of any approval or non-objection that the supervisor may have given. There are many provisions in here which contemplate a licensee applying for approval of this or that, and the supervisor can give it on terms, on conditions. And the violation of those conditions ought to be something that triggers the menu of regulatory actions that can take place. So either a breach of the condition of the licensee's license or of any condition imposed in relation to any approval or non-objection given. In 26 on the same page, 26.1b, which deals with suspension of a license, it says that a license can be suspended if a substantial shareholder or an officer has been charged with an offense involving fraud or dishonesty. Now, we have a presumption of innocence in this country under the Constitution. Being charged with an offense should not be a trigger that results in punitive action being taken. I don't think this is correct. It should say convicted, but not charged. I move to page 37. It's a curious provision because this is clause 30 on page 37. It says, every licensee shall ensure that each substantial shareholder and officer remains a fit and proper person. And if the licensee fails to do that, it's a criminal offense, and the penalties are severe. Now, how can a licensee ensure that a shareholder remains a fit and proper person? Or an officer. If an officer decides to do something illegal in their own life and ceases to be fit and proper, the licensee can't be criminally liable for that. That is a bad system of attribution of criminal liability. Even more so in the case of a shareholder who has no role in the running of the business. The proper sanction here is if a substantial shareholder or officer ceases to be a fit and proper person, then it triggers the suspension or revocation provisions. It shouldn't be a criminal offense on the part of the licensee. This is unheard of. And this needs to be reconsidered. I move to page 40 of the long form, clause 35. It's not entirely clear, but it appears to be saying that the account, well, 35.1 says the accounts of every licensee shall be audited annually in accordance with established international accounting standards by an external auditor. It says every licensee. But then 2 says, where the size of the operations of the licensee meets the description of a small company in accordance with the Companies Act, the accounts shall be prepared pursuant to the 7th schedule by an external auditor. There's no mention there of audit. It seems to be saying that for small companies that are licensed, there's no need to have the accounts audited. Speaking for myself, while I accept that policy in the Companies Act in relation to small companies, generally speaking, and indeed was one of the persons who argued for it when the Companies Bill was in the Joint Select Committee back in the day, if you're a licensee under this act and you're providing microcredit services, I would have thought producing audited accounts is a basic requirement. I can't see how any licensed financial entity can avoid having to have their accounts audited, even if they're within the small company definition of the Companies Act. And I would hasten to add that that definition is, it's not like a micro lend. It's not what a micro entity is defined as here. I don't remember the specifics of it, but it turns on turnover, asset size, and number of employees. And I think you have to meet 2 of the 3 in order to be a small company. But if you're licensed under this and you're engaging in financial services, you must have your accounts audited. I think that's elementary. This also impacts clause 38 on page 42, because it talks about the licensee shall ensure that the accounts of the licensee prepared pursuant to subsection 1 or 2 of section 35, which is a provision I just read. It's a little misleading because subsection 1 is the one that speaks to audited accounts. Subsection 2 suggests that they don't have to be audited without being very clear on the matter. But those 2 provisions, 35, 1 and 2, and 38, 1, need to be reconciled. I turn to page 45 of the bill. Now, and this is page 45, it's clause 41. And I make the general point in relation to clause 41 that in this legislation we're setting up yet another appeal tribunal. I hope there will come a day where we can consolidate all these appeal tribunals, which are proliferating across sundry legislation in many different sectors, into 1 or 2 or 3 specialized bodies, and avoid having to set up all these multiple appeal tribunals all over the place. That's a general comment, but the specific comment is that the scope of this appeal tribunal is very, very narrow. So having set it up on the legislation, the only thing that you can appeal to them on is a decision about a fit and proper person, or a decision about an objection as to whether an external auditor meets certain criteria. Now, that latter one is, in my view, going to be very rare. I think it'll be very rare that you're going to have any contesting as to whether or not an external auditor passes muster here, because they have to be registered public accountants, and they're not going to accept the appointment unless they comply with the requirements of the Act. So really, you're really talking about fit and proper decisions. And to set up an appeal tribunal just to deal with that seems pointless to me. There are a whole host of other issues in this legislation that we've criminalized, that we could have instead provided for some kind of regulatory sanction and had the appeal tribunal play a role in giving recourse to an aggrieved licensee. But we haven't done so. Instead, we've narrowly defined the scope of the appeal tribunal to one very small point, important point, but very small point: fit and proper adjudication. I turn to page 46, clause 43, and this is a peculiar provision. It says that the loan agreement must contain particulars relating to, and this is 1A2 now, the date on which the loan is made and disbursed. Now, in generally speaking, a loan agreement is signed prior to the disbursement of the loan. The loan agreement may have conditions precedent that the borrower has to comply with before the loan will be dispersed. There may be information that they have to provide. The security may have to be perfected. you're not going to know the date of disbursement when the loan agreement is signed. I don't know why we're expecting that to be something that must be. And bear in mind, if you're non-compliant with this, it's a criminal offense. We have made these provisions criminal offenses. I move to the next page, 47, which is the same clause, 43, 43(1)(a), and this is talking about, again, what the loan agreement has to contain particulars of. And in big D, it talks about the installments payable, and where the installments are weekly or monthly, they shall be expressed in both percentage rate of interest and dollar values. I don't know what that means. How an installment is an amount of money. I can understand that you must state in the loan agreement what the amount of each periodic installment, but I don't know how you express an installment in percentage rate of interest terms. I think that provision needs to be reconsidered. In the same clause, 43, subsection 2, which is at the bottom of page 47 of the long form of the bill, and this is talking about cash collateral, which is not a common form of collateral in microlending, because people usually borrowing because they don't have any cash and they need it. But it says here, where pursuant to subsection 1A4, property in the form of money is given as security for the performance by a borrower of his obligation, the money shall remain the property of the borrower and shall be held in escrow by a deposit-taking institution. Now, escrow arrangements are expensive because they require specialized documentation. They expose the escrow agent to potential liabilities. It's not the normal way in which cash-secured lending is done. Cash-secured...
The member's time.
Sorry.
The member's time for speaking has expired.
Madam Speaker, I ask that the member be given an additional 10 minutes.
I don't think I'm anywhere near the amount of time that the minister took, but I need probably 15 minutes. Yeah. Maybe less, but give me 15. I'm the only person speaking on the bill on our side.
The question before the House is that the member be allowed an additional 15 minutes to complete his presentation. Those in favor? Those against? The ayes have it.
Thank you, colleagues. I appreciate it. I was saying that this provision here that requires a cash collateral to be held in escrow is peculiar. The normal way in which this works is that the borrower would have an account with the deposit-taking institution and would sign a document. It used to be called a hypothecation. May still be called that in some instances. It creates a security interest over the deposit in favor of the lender. So to say that the money remains the property of the borrower, fair enough, but it must be subject to the security interest that has been created. That's the first point, and that should be stated here. And I don't see why it has to be held in escrow. That is just not the way in which cash secured lending is done. If it's in escrow, then it can't really be collateral. So that needs to be rethought. I move to clause 45 on page 49. Clause 45 says, a person who applies for a loan shall provide evidence of that person's ability to repay the loan. It sounds great, but it's just a statement which has no sanction attached if it's not complied with. So it really doesn't, it's not usual in statutes that you create an obligation like this with no consequences for breaching it. I note in 46.3 the requirement to reflect the rate of interest as an effective annual interest rate, and that must be the most prominently expressed rate in any advertising for the loan, and I commend that provision. I think that is a step forward. The requirement for rates to be expressed in a uniform way in relation to the interest charges, because there are all sorts of ways of calculating interest, add-on loans, reducing balance loans, and so on. And a borrower is often not aware of how much interest they'll be paying or what the real interest rate is. So this is a good thing. I note, however, that banks and building societies don't have to do this. You know, and banks in particular who are coming into this market of microlending will not have to comply with this. Similarly, there's a provision around penalties on default. Again, that provision doesn't apply to banks lending in this space. It only applies to microlenders who are licensed under this Act. This asymmetry in this section of the economy is not a good thing. I move to clause 50. Huh? I'm sure you will, but that's the way I see it. Oh. Give me the facts as you see them. On page 50, clause 48, 4, this is talking about investigating complaints. And it says that for the purpose of investigating a complaint made under this part, the Commissioner may, in writing, advise the licensee concerned of the general nature of the complaint and direct the licensee to furnish the Commission with such information as the Commission may require. I think that that should be a mandatory requirement. Certainly the first part of it. There must be an obligation to advise the licensee of the general nature of the complaint. It shouldn't be permissive. It should be, even if the rest of the clause is couched in language around may, this particular aspect of it should be mandatory. It's a basic natural justice requirement. I move to clause 49(2), paragraph J. Sorry, 49(2). And this is dealing with the code of conduct, that this, the Consumer Affairs Commission is being empowered to develop. And these microfinance institutions will find themselves being regulated by two regulators, really, because the Bank of Jamaica will be looking at them from a solvency point of view and prudential requirements point of view, and then the Consumer Affairs Commission will be looking at them from the point of view of how they deal with customers, and not just in the way that the Consumer Affairs Division deals with all economic actors, but in a very specific way with a whole regime applicable to them. So the regulatory weight of this legislation is quite heavy on what are quite small institutions. But the point I want to make in relation to this clause is that this code of conduct is to be formulated after consultation with the supervisor, which is the Bank of Jamaica, or such other person as may be charged to carry out similar functions. And then it goes on to say, and any other person who, in the opinion of the Commission, are relevant stakeholders. And I was just wondering why it didn't specifically require industry associations to be consulted. Why not specifically mention them? Even if you don't call them by name, you can use generic language. Why leave it to the Consumer Affairs Commission to decide whether or not they're a relevant stakeholder when it comes to such an important matter as the development, consulting on the code of conduct? I move to page 55 which is clause 54. And it says that, and this is dealing with the winding up of licensees, and it says, subject to subsection 2, the winding up of a licensee shall be subject to the provisions of the Insolvency Act. But subsection 4 says you can't go into a voluntary winding up unless you're solvent. Because 4 says a resolution for voluntary winding up shall not be effective unless the supervisor certifies that the licensee's realizable assets are sufficient to satisfy the claims of creditors. So it has to be solvent to go into voluntary winding up. And the Insolvency Act doesn't cover solvent liquidation. So that, I think, needs some further thought. I'm just going to move quickly to the third schedule. I don't want to stay beyond my 15 minutes. The third schedule on page 71 of the long form bill, it makes reference to sections 3 and 46. The 46 seems to be a wrong reference. I don't think it's 46 there that deals with the third schedule, so that should be looked at. And looking at the third schedule, part A, I also already mentioned item 10 in that list, which is generally interpreted as meaning that company borrowers loans to companies don't fall within the Act, which would make sense because there's no protect companies from a consumer protection point of view. I would just say 7 and 14 seem to be saying the same thing in different ways, so they're duplicative. And the other point I wanted to make was about 12, item 12 there. Most of the list is dealing with different categories of entity, like, for example, a specified financial institution, a society registered under the Cooperative Societies Act, a building society, etc. And then 12 says, any entity that extends credit to its customers for the supply of goods and services. Now, I don't think that you're really trying to exempt entities that may extend credit. Supposing they are in the micro-lending business, but they also provide some form of supplier's credit for services or goods. They shouldn't be exempt for that. The transaction can be exempt. In other words, the extension of credit to customers for the supply of goods and services is a different form of credit, really not covered by this Act. But the entity shouldn't be categorically, as it were, excluded because it may be doing other things that bring it within the scope of the Act. So this thing is, in this case, it should be the specific form of transaction that is exempted rather than the category of the entity itself. Madam Speaker, as I said, I just had a chance to look at this morning. I didn't get a chance to consult with the industry. They had consulted with me when the bill was tabled in 2019, but the rush in which this is being done makes it very difficult. I think I've said enough to indicate that I think there's a grave need for this bill to have a further technical review, but I understand the exigencies that the minister is under, unfortunate as they are. So we support the bill, but we have grave concerns about the process and aspects of what it says currently. Thank you, Madam Speaker.
Thank you very much, Member. Thank you for your contribution, and thank you for your indulgence in the matter and understanding. Thank you very much. Members have indicated we're asking our contributions to be as tight as possible.
Thank you, Madam Speaker. Madam Speaker, the Speaker before me, as I think outlined in very clear terms, that there are technical weaknesses and some technical issues that the bill represents. My brief contribution, Madam Speaker, looks really on the impact of the bill. Should the bill be passed today, and the Minister no doubt has a timeline and wants to press ahead with this bill, but I think as the spokesperson with responsibility for industry and investment, I must point out, Madam Speaker, that having adumbrated the technical concerns in this bill, the next question really then is, what then is the likely impact and effect of this bill in the sector and on the institutions? And I would say, Madam Speaker, that the issue... No, you'll have a chance. You'll have a chance, but not everything he said is wrong. I don't think you're arguing. No, well, not everything he said is wrong. What I will say, Madam Speaker, that at the end of the day, the issue really will come down to whether a reasonable balance was struck in this legislation. That really is the question. Was a reasonable balance struck in this regulation? Because at the end of the day, at the end of the day, there is no question but that the sector is very critical to addressing the issues of poverty, the issues of growth and development, and for the livelihood of a number of persons, both those who are employed by the sector and those who are benefited from the sector. And so the government recognizes, as all of us do, that this sector is a very critical sector. It has broad implication for matters of inclusion in the financial services, and more generally, access to financing that so many of our institutions, so many of the potential for unlocking growth and development in this country suffers under. So, Minister, when I again, this is a piece of legislation that has been long in gestation. In another capacity, I had to deal with this, and we're all encouraging of it, because the industry itself recognizes the need for regulation. So there's no argument about the necessity for. The question, it therefore raises a number of other questions about the nature of the regulation and whether the regulation, having been developed, strikes a balance. And the observation about the criminalizing of so many of the activities, I believe is continue to be a cause of concern. There's been, some of it has been addressed based upon the 2019 version. Some has been addressed, but it remains essentially a sort of gotcha provision, a number of gotcha provision in which persons who currently are in the system and persons who may wish to be in the system, come in the system and to improve the system, are going to have second thoughts about. And so from an industry point of view, and certainly from an investment point of view, I have grave concern about the implication of this bill for the industry and its effectiveness, and for attracting new investment in the sector. I must give a comment about those already existing, those who have invested in the sector already. They will be required to make substantial adjustments, as the Minister recognizes, and I've said. They'll be required to make substantial adjustments, and they've been given a year in which to do so. The question, to my mind, is not whether they will successfully make the adjustments. The question really is, what will we have left from the existing players in the sector? Because this legislation changes the risk calibration for all actors in the sector, and they will then have to now make the examination and come to a conclusion as to whether this incentivizes them in any way to continue in the operation, or whether they're not cutting their losses by exiting the sector. Those are some of the critical issues I think the sector is confronted with, and I'm very concerned about its impact on the industry and on investment going forward. Thank you.
Thank you very much. Member from South East St. Catherine. 1 second.
Thank you, Madam Chair. Madam Speaker, sorry. Thank you, Madam Speaker. I rise to support this bill and to give my contribution to this bill. You see, Madam Speaker, I went through the bill, analyzed it carefully. I am very interested in Part 7, subsection 42 to 53 in particular. You see, Madam Speaker, I have the privilege to represent the beautiful people of Southeast St. Catherine. In that constituency, it envelops a lot of small businesses. And time after time, people would visit the office of the Member of Parliament for a little injection in their business. Not that one. We all analyze that small businesses are vital in our economy. And this bill, Madam Speaker, shows that we have a government that listens to the people, that is caring, and also protect the rights of its citizens. Madam Speaker, if a person should go to a financial institution to borrow $100,000 at 20% interest rate, many persons do not know what 20% is. And time after time, sometimes financial institution will add a little. This bill tends to satisfy that mystery in protecting its consumer. Protecting the consumer. Madam Speaker, if a person borrow $100,000 at 20%, that person will know beforehand that they will pay $120 in total. And the time that is prescribed for them to pay that amount. So that person will have it in their heads that they'll pay at least $10,000 per month. Madam Speaker, this is a bill that caters to that mystery. This is a bill that caters to the consumer, and this is a bill that protects our industry. So I encourage my colleagues to support this bill and support the will of a caring government.
The member from North Trelawney.
Madam Speaker, permission to speak from a seat that is not my own. I rise to make a contribution to the microcredit bill. My research of microcredit facilities indicate that they were designed to overcome credit market failures and help low-income borrowers take advantage of investment opportunities. It expanded access to credit around the world, typically in the form of small business loans with relatively high interest rates and immediate weekly, bi-weekly, monthly loan repayments. Madam Speaker, our local reality, however, is that microcredit services are not being used as capital for business purposes only, but are also used for consumption. The services are used by individuals in need of help to deal with emergencies, to make critical purchases that could not otherwise be afforded, pay bills, and put food on the table in times of scarcity. This means that these borrowers aren't generating new income with the initial loan to assist with repayment, and oftentimes end up having to take out another loan to repay the initial loan, which creates a vicious cycle and translates into a lot more debt. In exploring our classifieds, I observed that for the numerous payday loan advertisements, one thing is clear. It serves to entice persons to apply for loans as low as $20,000 and as high as $5 million for any purpose within a 24-hour to 3-day turnaround, and with some becoming due on payday, with processing fees ranging from $1,000 to $3,000 and interest rates ranging from 3% to as high as 40%. Some microcredit lenders charge interest rates on the full amount of the loan rather than on the reducing balance, and some borrowers are bullied and humiliated in repayment. This puts a lot of pressure on individuals who end up resorting to the office of the Member of Parliament for assistance in the repayment of these loans. For the last 4 months that I've occupied this post, that has been my reality, and especially so now during the pandemic. Madam Speaker, there are microcredit entities that provide other services like accounting, general management consultancy, debt management recovery, the sale of appliances, and the operation of pawn shops, while also providing what they call cash in a flash, with sometimes no credit checks. I think we can use our imagination to determine how pawn shops and microcredit facilities complement each other. It is against that background, Madam Speaker, that the need for consumer protection in this type of environment becomes paramount. Borrowers need protection. They have rights. I find it heartening that this bill seeks to provide the necessary protection to our most vulnerable. What must be highlighted is that the bill does not recognize the provision of a credit facility to high net worth individuals as a microcredit service. So it is restricted to persons below a threshold. With that said, Madam Speaker, I highlight the role of the Commission as established under the Consumer Protection Act in having the responsibility for investigating complaints brought by a consumer of microcredit service. There are industries that I'm aware of that have been crying out for this type of intervention, and so I commend this move. I also highlight the requirement for microcredit institutions to provide the consumer with a loan agreement, which must contain information relevant to the credit facility, including the rate of the interest chargeable per annum, the period of time given for repayment, the date on which repayment falls due, the installments payable, how the interest rate on default payments are calculated, as well as even the full cost of the loan expressed in both percentage rate of interest and dollar value. The property, if any, being given as security for the performance by the borrower of his obligation must also be contained in the agreement. It is a requirement for the language of the loan agreement to be clear and unambiguous. And where technical language is unavoidable, such language is accompanied by an explanation in simple language that is not false or misleading. Madam Speaker, effectively, borrowers will now be able to refer to their own documentation to remind themselves of how exactly they should pay, when they should pay, how long they have to make payments, and the actual rates of interest per annum to be paid. That places some amount of power in the hands of the borrower, as currently there are persons who have indicated that they have no idea of their terms of payment or the facility extended to them, and are sometimes hauled before the courts because of misunderstanding of the terms of the loan. Consumers will also be happy with the contents of Clause 46(4), which stipulates that the interest and any penalty to be paid on default of payment of a loan shall be calculated on the outstanding balance of the loan and not the original principal sum. Microcredit facilities will now be required to establish mechanisms to address consumer complaints. They will be also obligated to report and record consumer complaints and resolutions within the time and format specified by the Commissioner. The Code of Conduct to be developed will also outline the lawful methods of enforcement available where a borrower has breached the repayment terms of a loan and will provide measures to be taken to facilitate access to microcredit services for senior citizens and consumers with disability. We should be proud of this move. I am also particularly pleased with the sanctions imposed for the use of violence, threats of violence, or other criminal means employed to harm the physical person or property of the borrower in the recovery of any debt owed to a microcredit facility. Madam Speaker, with all these rights must come some responsibility from the borrower, and so it must be noted that if they apply for a loan, they have an obligation to provide the evidence of their ability to repay the loan, and they must adhere to all payment terms agreed. There must be balance imposed. Thank you, Madam Speaker.
The member from Northwest St. Catherine.
Northeastern, Madam Speaker. Madam Speaker, as a representative of St. Catherine Northeastern, a seat that has many ambitious, hardworking, but struggling small businesses, humble businesses, subsistent businesses, I support any framework that seeks to protect the people. Madam Speaker, I note a concern that was raised that we do not want to become so restrictive in framing the law that microfinancing institutions may not have the room to grow and thrive. But, Madam Speaker, I put it to this House that what this bill seeks to do is to erase those grievous practices and encourage wholesome business practices. Madam Speaker, I'm very happy that the member from St. Catherine spoke about some of the expectations of a member of Parliament. It is very rare when we have a constituent who speaks to us about a policy or a legislation. So I've had the experience where a constituent called me and she said, MP, lend me $25,000. And I said, lend you $25,000? What happened? She said, MP, me shop. Them are going to lock down me shop, me might go jail. I said, what happened? And she explained that she got a loan. And she have to go pay it back. And I said, then you took out a loan. You must understand that you have to pay it back. And then she explained to me, MP, me did plan to pay it back. But things got bad and the loan get away from me. We better believe that there are so many of our people who are in this kind of vicious cycle of poverty. Madam Speaker, I also served on a board, and a matter that came to the board was a matter of loan sharks. When we talk about predatory practices, waiting for them at work. Many of them, they have to be hiding in the bathroom. And I also have an unpleasant experience, member, where one morning when I opened my shutter, two men actually jumped in the garage. Yes, wrong house. So they said, is this number 25? Of course, I was shaking. I said, no. So what? And they now explained the story that somebody owed them and they wanted to seize. They wanted to seize TV. So it was really my first brush with that experience, Madam Speaker. It was scary, and it was then that I had an appreciation of the agony of what many of our Jamaicans go through. Ambitious Jamaicans. And Madam Speaker, I would want us to erase the stereotype that banking is for the big man. And I encourage the big banks to somehow, in your outreach, embrace, broker a relationship with the people. Because sometimes your fees are not necessarily unfriendly, but there's a small man up in northeastern St. Catherine who believes that banking is not for him. And we have to play our role in changing that. Madam Speaker, as some banks, because I believe that it is related, as some banks are making the move to become digitized, please remember that section of our society where there may be a fallout. People who aren't on par with the latest technology. And when they hear that they have to go, they go to their bank now and they can't get maybe the service that they're accustomed to. Remember that there are those out there who may prey on this particular vulnerability. So banks not accepting cash. So what is going to happen to that farmer in northeastern St. Catherine who may not know how to transact otherwise? We have to take into consideration the fact that we are as strong as the most vulnerable amongst us. So we encourage people to ramp up education campaigns. The minister made mention that we want our people to have the option, whether they go to the bank, whether they go to a building society, or whether they choose to go to the microfinancing institution. That can only come through financial literacy. And I saw a note that financial literacy is just as important as the other basics of life. In closing, Madam Speaker, the single biggest difference between financial success and financial failure is how well we are able to manage our money. And we want a Jamaica, this administration wants a Jamaica where people learn about dollars and cents. We want our people to be able to build, grow, thrive, prosper, and make sound financial decisions. If it so pleases you.
The member from Western Westmoreland? Western Westmoreland? Not? No?
Yes, Madam Speaker, permit me to speak. Yes, Madam Speaker, permit me to speak from a seat that is not my designated seat. As the elected member of Parliament for Westmoreland Western, I rise on this special occasion to make my contribution to this very important bill. In Jamaica, we have registered more than 40,000 businesses. During the COVID pandemic, we saw a spike in the registration of new businesses, which means that we will be requiring more financial assistance and services. Access to financing, liquidity, and cash flow are the heartbeat.
Yes, just a short time. Please let us hear him.
Access to financing, liquidity, and cash flow are the heartbeat of small businesses. And anyone who operates a small business will know that this is how they grow and thrive. Microfinancing has become a necessary part of our financial landscape. And as time evolves, we find that the big banks are not either eager or ready to take on this particular challenge. Negril, a section that I represent, placed in my constituency, has many, many small businesses. We find farmers, we find micro, small, and medium-sized enterprises, we find shopkeepers. And on my constituency days, which is quite new to the constituency of Westmoreland Western, every Thursday, I will find a list of persons who line up in particular seeking financial assistance to support their businesses. Just last week, Thursday, I was fortunate or unfortunate to have one visitor, a single mother, matrifocal home, where she had 5 kids. She borrowed a small loan to purchase a taxi. And this taxi was seized by the microfinancial institution. This taxi cost $1 million, and this is facts. And she had outstanding $250,000 with a penalty of $100,000. So she was seeking $350,000 to clear this microfinancing debt. When she got that money, which I arranged successfully to do, we found, we saw where upon going to retrieve this taxi, she was then asked to pay the bailiff fee and the record fee because it was record to St. Elizabeth, which cost another $150,000. So she's still in the same predicament, and she's been threatened that the car will be sold within a week. When I hear this bill being presented, I was quite encouraged by the minister, because it shows that this government is not only listening and cares, but they have the will to take the necessary action to protect the people of this beloved country we call Jamaica. So on that note, I would want to say congratulations to the Minister of Finance and the team who crafted this bill, and to support it wholeheartedly. There are 3 components which I am in full support of. One, the holding of license, which will see that if someone loans monies without the proper requisite license, that contract is unenforceable. Confidentiality is also a key part, and I suspect that players within this sector will be encouraged and welcome that confidentiality will not only enhance the confidence, but it also put a section of professionalism to the entire sector, which is required. The use of violence is a particular issue for me because, as I said, there are many, many of my constituents who are users of these microfinancial institutions. The use of violence is I'm very encouraged for the use of violence to be a criminal offense, because on that note, it will say to the lenders and those who are up to their nefarious actions that we are not tolerating this for the Jamaican people as a government. So in closing, I support this bill. It not only identifies the financial challenges, but it also takes steps to correct the market failures that we have been having within the financial sector. I thank you.
The member from Central Manchester.
Stomp them now, stomp them. Stomp them.
Madam Speaker.
Period. Let us hear her.
Stomp them.
Madam Speaker, having risen in the House for the first time, permit me to acknowledge and thank the good people of Manchester Central for their love and support. Madam Speaker, my constituents have not sent me here to be out and stunting, but in But instead, they have sent me to represent their interest and by extension the interest of the Jamaican people. Madam Speaker, the bill before us, the Microcredit Act 2021, is of real significance to my people and I. We are particularly pleased with the provisions contained in Part 7, Clauses 42 to 53, which speaks to the protection of the consumers, more specifically, Clause 46, which speaks to interest rates. Madam Speaker, in my few months as Member of Parliament, I have come to the realization that what our people want in order to escape poverty and or to realize their dreams and goals is help out, real opportunity, not handouts. I have seen and heard of countless accounts where ambitious and independent-minded individuals, in their quest to achieve better, to get things right, have sought a jumpstart or emergency relief from lending agencies who have become loan sharks, only to instead become victims of abuse, prisoners of high interest rates, and have otherwise become nomadic when they are unable to repay. Take as example a single mother who needs to pay $100,000 to avoid the deregistration of her child at the university. This mother, Madam Speaker, with very little option, is forced to sign for a loan at the repayment rate of $280,000 out of desperation. Madam Speaker, as one who have had to overcome hardships, a great deal of hardship, and one who saw my own mother having to borrow money to pay my first-year tuition to enter teacher training college, and had to struggle thereafter to pay very high interest rate well after I had already completed my first year, I have to support this bill. For you see, Madam Speaker, this bill will regulate interest rates to allow the little man to benefit from hassle-free and reasonable loan. Madam Speaker, I thank you.
I'm going to ask member from South East St. Mary. Members, I really would like you to listen to the people so that they can get through their presentation and we can go through the bill clause by clause and the members of the House, the workers, all of us can go home. Please.
Madam Speaker, I rise to support the bill entitled Microcredit Act 2021 as a Member of Parliament from South East St. Mary, a rural community. Small businesses are the lifeblood of every country, and here in Jamaica, the same is true, that micro and small businesses are the lifeblood of this country. Contributing significant employment to individuals, significantly paying taxes, and significantly changing the lives of many Jamaicans. Madam Speaker, there are over 420,000 small businesses in Jamaica, contributing almost $74 billion in taxes and represent almost 3.5% of the GDP. However, small businesses in most cases rely on microcredit facilities to fund their businesses. These microcredit facilities, we must admit, has an important role in the life of businesses. However, we have seen from time to time, and we have heard from time to time, anecdotal evidences in most cases where small businesses are literally at the mercy of these agencies. But notwithstanding that, we have to pay credit also to the microfinancial agencies, because they have provided an avenue where others have failed to do so, and so that persons, Madam Speaker, can access financial resources and sometimes advice as well as they conduct their businesses. Therefore, for this, I want to salute the microfinancing agencies. Madam Speaker, however, there are many pluses and commendations that can be given to these agencies for the way most of them have conducted themselves without intense regulations. But because some of them, due to their excesses that we have seen, have brought to bear on small businesses that seek assistance, we must therefore act. And the time is now. As a government, we always look out for what is best for the people of this country. We enact legislation and we try to regulate. But for sure, Madam Speaker, we're not over-regulating. We need to bring order to this sector, as well as inclusion in a national financial inclusion strategy. We care. As such, the tabling of this bill in this Honourable House is welcome, Madam Speaker. It has been a long journey. It has spanned successful and consecutive administration. Yes. And I now think that we have a bill that we can be proud of. Madam Speaker, we want to say that Jamaica's evolving financial landscape is of such that we will continue to develop legislation that we believe is in the interest of not one group or any one group, but for all Jamaicans, as we seek to continue to build a Jamaica where transparency, accessibility, where accountability, where the rule of law, where the operations can be interrogated in such a way that it stands up not just to international scrutiny, but to the scrutiny of the ordinary Jamaican person. Madam Speaker, we have a legislation that is in the interest of the people of Jamaica. The government, therefore, Madam Speaker, must feel the pulse of the people. And as the Minister of Finance mentioned recently, the government must be more responsive to the citizen. And therefore, we must be enablers to ensure that the services that we provide and require is what the people of Jamaica will get. Government does not have the luxury of standing by and watching where appropriate legislation is in fact required. Needs to be done, because it would be a dereliction of duty if we stand by and do nothing. Madam Speaker, therefore, as long as this government is here, we will find the fortitude to ensure that bills are enacted in the interest of the people of Jamaica. So what we are doing here, Madam Speaker, is strengthening the MFIs in Jamaica. And they have been doing, which have been functioning for a long time. We have been good stewards, and they have been good stewards in most cases of their finances and their conduct. And for that, we continue to salute them. However, as with any organization, there will be individuals that have behavior that we do not share, and therefore we have to look out for those individuals. And Clause 53 in particular speaks to the transgression, I believe, that a number of these agencies conduct in order to recover the money that they have loaned to persons. That is what we want to prevent, Madam Speaker. So, as we look at Section 46, which speaks about interest rate, and this has always been of major concern to the people of Jamaica, and therefore it is important that this be brought to bear on the microfinancial institution. As you can see, Madam Speaker, for what is tabled here today, it is a very responsible approach that has been taken. We are not here to limit persons. We're not to create a ceilings or floor by which they must operate in or where the interest rate must go. But what we have said to them is that here we have to ensure that the requirements of loans are done in such a way that persons can see for themselves all that is required, and therefore there's nothing that's behind the dark that they're not aware of. So, Madam Speaker, I am a product of MSME sector in Jamaica, and I know what it is to be refused a loan from the traditional lending agencies. And I'm sure a number of my colleagues here in this House can testify to that. But I'm saying that their refusal is not because they do not like small businesses. Absolutely not. They have their rules and that they have their criteria in which they function, and therefore the microcredit financial institutions have to step in. And a number of cases where the traditional lending agencies would think that the risk is too high to take on those businesses, the microcredit agencies have stepped in. So, as to what we have seen in my case, I've started a business, and therefore we have to applaud the MFIs on taking on that particular risk. We have to applaud them, not that others would have taken it on, and we have to applaud them by the way that they conducted themselves over time without regulations. And most of them, we have to applaud them from embracing the fact that the Microcredit Act is, and not only in their interests, but we, by taming this bill here, is to support their cause. It is in the interest of bringing order to that market where there are so many players, over 300 players in that market, and to ensure that order is brought there and that the functioning of such that all the behaviors that we as Jamaicans do not want to see raise its head does not raise its head. Therefore, Madam Speaker, I support this bill. And I support this bill from the premise is a tool for the microfinancing agency requires. But the time has come, and the time is now for us to become supporters of the microcredit agencies, not just policemen, because the consultation that has ensued in bringing this bill to the Parliament here today is what we can say we are proud of. And therefore, Madam Speaker, it is with great pleasure that I support this bill. Thank you.
Our last brief contribution will be from the Attorney General. Emphasis on brief.
Thank you, Madam Speaker. I rise to support this bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small and medium-sized enterprises and for connected matters. The bill that is shortly entitled the Microcredit Act 2021. Madam Speaker, my comments are going to be a little different from those who have spoken before, but as I sat and I listened, I couldn't help but feel pleased, because laws can be technical, and sometimes when we're going through the process, there isn't the rapt attention of everyone in the House. But this is one bill that just about every member of Parliament can relate to. And as I listened to borrow the term from another jurisdiction, the freshmen in this honourable House, I felt good, Madam Speaker, because I know the constituents who have entrusted their confidence in these representatives are looking on and are feeling proudly to hear how these are ensuring that their interests are protected. But you know, Madam Speaker, when I was in another role and I sat in a place just on Sutton Street there, I used to deal with a lot of matters involving this industry. And you know, Madam Speaker, something struck me then. A lot of the cases that came before the court for breach of contract, where the plaintiff was the lender and the defendant was the borrower, in many cases, the borrower had repaid not only the principal sum, but a significant amount in interest, but had fallen short of the full payment. And when I inquired, as the minister spoke about setting out the formula for computation and ensuring that upfront all the expenses are known and are calculated and are accounted for, I couldn't help but wonder about the consciences of people. Because, and it is not to knock anyone, because a business is a business and people will take advantage of opportunities. And as a member before said, that the industry grew out of a real need to provide financing, where the other financial players had failed to provide. But you know, Madam Speaker, what I really want to focus my contribution on is to highlight from among the objects and reasons of the bill, the government's recognition not only of the need to protect consumers by bringing order to the operation of microcredit institutions, but also its recognition of the need to ensure that those in these industries are not used to facilitate money laundering and terrorist financing. Now, the Honourable Minister began his presentations in this Honourable House today by giving an update on where this jurisdiction is in its compliance with the anti-money laundering and counter-financing of terrorism regime through the CFATF and the FATF. And among the questions asked was what would it take for Jamaica to be in full compliance? Because the consequences of non-compliance are huge. Jamaica does not exist in a vacuum. We live in the community of nations where actions in one jurisdiction impact us here, and what happens here has significant consequences for how we are viewed in the wider system. And the Minister indicated that passing this bill would be critical. Why have I highlighted that, Madam Speaker? The Honourable Member, who is the Leader of Opposition, began his presentation in what I received as a very sanctimonious manner. Why do I say that? Why do I say that, Madam Speaker? There is a reason for my saying it. It's not mean criticism. Madam Speaker, I came to the Parliament first in the other House. First in government and then on the opposition benches. And I recall in that term on the opposition benches when we were under the IMF program, very often bills would be brought to the Senate and the standing orders would be suspended and we would be asked to take them through all of the stages in a single day. Complex bills. And we would raise the concern, allow us to scrutinize these bills, allow us to read them, and we would be met with such arrogance about and hostility about the need to have them passed because there were critical timelines. And so, you know, that practice, Madam Speaker, institutionalized an approach because things were rammed through. Now, on this bill, the Minister at least tabled it a week before, and I know this Minister, who also had a term in the other House, is very mindful of these issues. And so he endeavors to be fair and to give time because he appreciates the significance of these matters. So to come here, Madam Speaker, and put on the record of this Honourable House that this government is taking an approach that is not allowing for the kind of interrogation and the kind of discourse is simply not true, and more so not true coming from that member who spoke about it. So, Madam Speaker, this is a good day for the people of Jamaica because there are real problems in this industry. It is not about putting anyone out of business who is operating in the industry. It is simply a day of reckoning, that we have to come to terms with how we do business, and we have to be mindful about those we are serving. And I know that the people of Jamaica will be better off for the passing of this bill. May it so please.
1 second. Just before you begin, Minister, I just want to say that it is a good day for Jamaica, and I want to congratulate all who contributed to this debate on both sides of the aisle. I think what I got from all the contributions is that all the contributions that were made is the fact that as members, we all salute the part played by the microfinancing agencies. But I think the member from North Trelawney said it very succinctly. Where you have a privilege, there is a responsibility. And so in the same way that we have a privilege and we must salute, and I also want us to recognize in the democracy that it is important that the opposition lays on the table what has to be done to keep us aware. And I also want to congratulate, because the leader of the opposition did say he had concerns, but he was in support of the bill that was before us. And in so doing, he was giving and lending his support to the bill. So I think it is a good day for Jamaicans, because as a people, we benefit from the bill that has been brought. And I also think it is a good day because on both sides of the aisle, we have been engaged in a vigorous debate, and everybody has contributed, particularly our young parliamentarians, which we are extremely proud of, and they brought a sense of reality to the debate. It's what's happening with them that they are feeling on the ground, and they have brought us. But I, sitting here, must create a balance, and I must say that I want to congratulate all our speakers on both sides of the aisle, because I would not like, as a speaker, for us to have no opposition that is lending their own voice to their concerns as we put the bill. But we have their support, and I also thank the opposition for their contribution and the support, as much as I welcome the support and the energy from the government side, particularly your young people. Thank you. Well, for sure, democracy is alive and well, and we are proud of the way we operate in this parliament.
Madam Speaker, the future is bright. We heard from energetic, articulate members of the government side in the House. But you know what is most important, Mr. Speaker, Madam Speaker, is that we heard from members with a heart for the people of Jamaica. This is an industry, Madam Speaker, as Minister of Finance today in an unregulated industry. I have to sign exemptions from the Money Lending Act for all of these entities to continue doing their business. So they come and they present, and the files are thick, and the number of persons who are served by these institutions don't number 100 or 1,000. We're talking over 100,000 Jamaicans who depend on the 5% a week and the 10% a month loans. This government has a heart, and we are intervening on behalf of the consumers of Jamaica. Now, I can well understand that the opposition wish that they were the ones who brought this bill to the House. I understand that. No. Hello. No, Madam Speaker.
You know, members, we have had a good day.
With respect,
let us complete a good day.
With respect, Madam Speaker, I just want to address some of the points that were made in fullness before we move to the clause by clause. And I think Time is absolutely of the essence. So the bill, Madam Speaker, would have been originally tabled some time ago, February 2019, and since that time, we have engaged with discussions with the sector and with the sectoral representatives. They have seen updated drafts, and even before the debate today, the BOJ was in touch with, well, certainly sent them the bill as it came out last week, has been in touch with the larger of the two entities, and has received positive, I won't even say support for the bill. Okay? There may be things I'm sure that one or two people may object to, but this is not something that we have done without consultation. Now, as the Attorney General mentioned, I sat in the Senate, Madam Speaker, where when things needed to get done because of external commitments, we at the time would have obliged. And I believe that that is what overall, even though overall I have heard from the opposition, this is a serious matter at the end of the day. It's a very, very serious matter. Jamaica, under our mutual evaluation, which was done in 2015 and published in 2017, the risk posed to the financial system by an unregulated microcredit sector that was growing leaps and bounds was seen as sufficient to put Jamaica, among other deficiencies, on a blacklist. Now, that is not something to play around with or to joke with. Indeed, right now, there are certain banks in Jamaica who have refused to bank microcredit institutions. They cannot provide their service indefinitely without commercial banking service. So many of them want to have the regulations in place so that this threat of de-risking, of de-banking, does not impede their business. With respect to the penal measures and the criminal offences, Madam Speaker, what is happening is that we have to deal with the situation that we have. We have 200 and odd of these entities. It might be the case that 5 years from now there is amalgamation and we have, maybe not as many as 240 and they're bigger and they're stronger. But we have to deal with what we have now. And the situation we have now is that we have excellent service providers, no doubt about that, and good corporate citizens. But among them are entities that are bad eggs. The sanctions have to be sharp in order to get the compliance that is required. That's just a simple fact. It might be that when we review in 5 years and the situation is different and we have 90% of the industry that is doing well and complying, we might take another look. But today, you remember what I said earlier in my statement about how FATF looks at the regime. They want to see the effectiveness of it, not just passing the bill, but is it effective? Are you getting all of these providers to comply? And the nature of the sanctions is such to ensure that for our benefit, when they look on Jamaica, they see that there is compliance with the provision. So we never again go back to this position of being, I don't even want to call the name listed. It's so, the derogatory name that people use for it. With respect to the definition of microcredit service and institution, there is a circularity. And in the clause by clause, we propose to adjust it by not for microcredit service. We don't need to repeat a service provided by a microcredit institution. We can leave that part out. And that was a good comment. The comment made on the asymmetry with banks. So the comment was that banks are now entering this industry and they are providing microcredit service to individuals and small businesses. But wait a minute. But the banks are regulated on a different act. They're not regulated under this act. So is there going to be an unfair playing field with respect to the publishing the interest rate and so on? I want to assure, when I alluded, talking cross-talk on the facts, I just want to assure members, I totally understand the comment that's being made, but when it comes to disclosing the effective interest rate, that whole provision and how the effective interest rate ought to be disclosed was drawn from the code of conduct that the BOJ put in place for financial institutions. It's not the other way around. this provision here on disclosing the effective interest rates, where you add up the fees and you add up all of the costs and the interest and you divide it by the principal, that comes from the code of conduct. So with respect to the provision of information and disclosure of costs, there's no asymmetry. The mechanism is different because we're at a different stage of development, and a code of conduct between that all banks have to sign will mean that they have to abide by that particular provision as well. With respect to the transitional provision, that's something that we can, when the appointed day occurs and we make use of the transitional position, that's something that we, if I'm understanding the comment properly, that we could incorporate. With respect to, I mean, there are a number of comments that were made that express the particular, peculiarities that the member would, the former Attorney General, who was in the role of looking at legislation, and in his own way, that's how he would particularly do things, which I totally understand and respect. On many of those, we differ, and we differ for reasons. An example would be the appeals tribunal. It is necessary.
Madam Speaker, the time being 7:20, I ask that the House be allowed to sit beyond 7:30 to complete the business of the day.
Question before the House is that the standing orders be suspended to allow the House to sit beyond this time. And as I do so, I urge the member speaking to hasten his presentation so that we can go in. I just want to remind members that the people who make Parliament work are the staff of Parliament. And when we're through and we drive away, they have to close up and they also have to get home. So that's why it's important. We want to do the work, we must do the work, and we must be mindful of the people who help to make the wheels turn. So, Minister, I'm trusting you're going to wrap up.
Thank you, Madam Speaker. Fully cognizant of that. I just need to respond to the points are on record and they need to be responded to. So the comment was made about appeals tribunal, and I had made it in my original presentation to say that we're setting up an appeals tribunal for entities to be able to appeal decisions of the supervisor. The member spoke to the fact of a proliferation of all of these appeals tribunals, and he's correct, because we do have, in legislation that's come before this House, a number of these provisions. Now, it's good that we have appeals processes and regulation, but indeed, having so many of them at some point, we may need to clean up. But the industry, when we first, in our engagement with them, they expressed the view that coming under the banking supervisory appeals was suboptimal. And we understand. The truth is, we have 240 of these entities. Our licensed commercial banks are 5 or thereabouts. So you can understand that just by numbers, there is certainly, and it's certainly at the beginning, there's going to be a need for them to have a dedicated facility through which they can make appeals. We expect in the first few years of this regulation, as it is put into practice and as people get used to it, there will be appeals. So I am sympathetic to the view, but we have listened to the industry in this regard, and I don't doubt that in the future there can be some consolidation of all these appeals tribunals. The requirement to put the date on which the loan is signed and dispersed, I understand what the member is saying. I mean, he's using the analogous situation in commercial banks when there's often a difference between disbursement and signing because you have to perfect security and so forth. The reality is that in this industry, so many of the loans are same-day loans, a lot of them in terms of volume. Many of them signing and disbursement is on the same day. I'm not saying all, but many. And given the nature of the customer that you're dealing with here, it is necessary to make that distinction. So the customer is aware when interest starts to tick. Okay? The interest, there can be a fee paid on signing, but the interest ticks on disbursement. And here we're protecting the consumer. Now, the member made much of this requirement in section 43(1)(a)(d) that, and if I can find it quickly, where there is a requirement to state the amount to be paid, both in terms of the dollar amount and the percentage, the installment, when stuff is done in installment. What the member is failing to recognize is this law here deals with the practical nature of the industry. You cannot put on a banking hat and interpret the law. Many of the loans given, sometimes they're given and they say you borrow $20,000, you're going to pay $10,000 every month for 4 months. And that is how the loan is termed. All the provision says is that if you make the loan an installment, where you tell the person you borrow $20,000, but you have to pay $10,000 a month for 4 months, you must disclose to the person what the interest rate is. Okay? Many people will say, oh, and it sounds easy. I get $20,000, I pay $10,000 a month for 4 months. Right? The implied interest rates could be 60 or 70%. That must be included. So it just makes the point that whether you specify the loan by quoting the interest rate or the installment, you have to have the effective interest rate in there. Right? So there's nothing peculiar about that. That just responds to the practical reality on the ground and the nature of the industry as we have it in Jamaica. There were comments made on cash collateral and the fact that cash collateral, having escrow agents, is costly. Yes, that is indeed the case. But remember, also spoke about cash collateral not being by any stretch of the imagination the main means of collateralizing loans in this sector. Not at all. However, if people choose to use cash collateral, we have to put in provisions where people are protected. And the way for them to be protected is to require that it's done properly. With respect to clause 45 and the code of with respect to the code of conduct to be developed by the Consumer Affairs Commission, it mentions stakeholders. It does not specifically say the industry association, but this whole bill was developed in consultation with those industry associations. We have mentioned the broader term, which is stakeholders. Stakeholders can be the industry associations, it can be customers, it can be people who are bailiffs, right? It can be anybody. It's a broader term, and to make much of it and to use this sweeping generalization of technical issues is not fitting, right, for the vast majority of the things that were mentioned. With respect to in clause 48.4, the requirement to make it, or the suggestion rather, to make it mandatory that this is what I'm sure, using this euphemism of technical issues to describe, and then under the veil of that to suggest that the requirement that if there's an investigation being undertaken, the member suggested that the licensee be notified in writing as a mandatory fact. The member is not understanding or not portraying in that comment and understanding how regulatory authorities operate. There are many investigations that start before the entity is aware. If you had law enforcement or regulatory authorities requiring that persons are notified in writing before an investigation begins, many of the contraventions would never be caught. So that is something that we completely reject and reject outright, and is another example of using this veil of technical stuff, and which is, it's unfortunate to use his standing in that way. In the third schedule, under Section 3, the member had a few queries which I just proposed to respond to. And the query, one of them was whether I believe lending to companies can constitute a microcredit service. The answer is yes, that if the company is an MSME, what the law provides protection to low-income individuals, right, and to micro, small, and medium-sized enterprises. So a business that is in the business of lending to MSMEs, that is caught under this bill. The comment about whether or not, or the question about whether or not item 10 in the third schedule, any loan or contract or security for the payment of money lent to a body corporate, his interpretation is my interpretation. There's a question that he asked. And then in 12, about any entity that extends credit to its customers for the supply of goods and services to be excluded, he was wondering whether or not this could be abused by microcredit entities. And that's not the case, because what the law requires is that even if you are in the business of microcredit and you have 20 loans, you're either in the business or you're not. If you're in it, you have to be regulated. And if you're in more than one business, you have to separate the microcredit business and have that business be licensed and regulated. So the concern, doesn't arise in the way that was being suggested. Now, Madam Speaker, it's taken a long time to get here. Lots of consultation. And when you are going to regulate an industry that's been around for a long time, has grown tremendously, that everybody is jumping into because they believe they can make returns, and we have over 250 of them around the country. Putting regulations in place, you're going to have pockets of resistance. That is to be expected. But we here, Madam Speaker, in government have the responsibility to respond to the challenges that we face. And in respect of this legislation, the challenges are multiple. There's a money laundering challenge and the grey listing of Jamaica that we have to address. And there is the important business of consumer protection and improving access to finance. And yes, the government of Jamaica, where we have had to make a judgment, we have on balance protected consumers. The persons who are customers of these institutions represent the more vulnerable elements of our society, and we have a duty to ensure that they are protected. There's no doubt, Madam Speaker, that having to pass the bill as now, there's no doubt that in the future we will find elements that we're going to want to amend. But the greater good is served by living up to our commitment to the Financial Action Task Force, which is our first commitment of 2021, and there are many others to come, to have this bill passed and to offer the protection to the consumers of Jamaica now and into the future. Madam Speaker, I close this debate and I ask that the bill be approved, and I ask for a second reading of the bill.
The question before the House is that the bill be read a second time. Those in favor? Aye. Those against? The ayes have it. Madam Clerk.
A bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small, and medium-sized enterprises and for connected matters read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause.
Member, given the time and given that we have the third supplementary to refer to the PAAC, I have 3 amendments that I would ask that I put to the committee, and if they're passed, thereafter, if we could take the bill probably in its parts. They're I think, 10 parts to the bill, and we could have taken it part by part.
Very well.
I believe an amendment sheet.
There is an amendment sheet.
There is an amendment sheet.
Please pass that to the minister.
And there is just one amendment that we're just going to introduce on the basis of the one of the comments made by the opposition leader. So the first amendment, Madam Speaker, is with respect to in Clause 8, to delete Clause 8, and in its place insert, in making a determination on license approvals or revocation, the supervisor shall consult with the minister on matters relating to national interest. The clause, as it is now, Madam Speaker, runs against the legislation over the past several years, where in supervisory matters, the minister does not give directions to the supervisor. There was an amendment in 2015, I believe, where in banking matters, the minister's power to give direction on supervision was removed, and obviously we, in a bill passed recently, we removed the power to give directions on monetary policy. So coming here and introducing a new direction that the minister could do would fly in the face of those two changes that have been made over one this year and one in 2015. And then we wanted to insert in the third schedule a clause that exempts the provision, even though it's probably exempted already if you put 2 or 3 clauses together, but we wanted to make it explicit that the provision of credit facilities by an employer to an employee or to a person in full-time service of the employer does not constitute a microcredit service, i.e. Company X has a scheme where it's lending to its employees, that is not a what we know from practice is that people do that out of companies do that out of the kindness of their heart, and we don't mean for the regulatory arm to be stretched to cover those activities. So those are the amendments that are listed, and then the amendment that arises from the opposition leader's contribution is in the definition of microcredit service, to remove the circularity. And that was a good suggestion, to remove well, it wasn't a suggestion, he just pointed out the circularity.
Which section is that, Minister?
This is in the definition, and it would be the definition of microcredit service. Now it reads on page 5 of the small bill. Right now it reads, any one or more of the following services provided by a microcredit institution. 1, the granting of credit facilities, etc. What I'm proposing is to delete the words provided by a microcredit institution. So it would read, a microcredit service means any one or more of the following services. Okay? So we don't have the circularity that a microcredit service is provided by a microcredit institution, and a microcredit institution means an institution licensed under the Act. Yeah, it's tautological. So instead of, we would...
Are inserting what?
It would say microcredit service means any one or more of the following services. Yes, I'm deleting 5 words. Provided by a microcredit institution.
Very well.
So those 3 amendments, Madam Speaker, I don't know if I could put them together en bloc.
No, I think
one by one. When we get to the sections.
To the clause.
So
yes.
I suggest you go clause 1, then we go clause 2, and then we move from there.
Thank you, member.
Members, I now put clause 1. Those in favor?
Aye.
Those against? The ayes have it. I now put clause 2. Those... No, we don't have an amendment.
Madam Chair, we're suggesting amendment to the definition of microcredit service.
Okay. clause 2 as amended.
No, Madam Speaker. May the amendment be read in the record in relation to clause 2, in terms of the definition?
The definition of the term, Madam Chair, microcredit service, it would be amended by deleting the words provided by a microcredit institution.
Members, we put the amendment to clause 2, which is the deleting the words provided by a microcredit institution and instead insert any one or more of the following services. Those in favor? Aye. Those against? The ayes have it.
No, Madam Speaker. I'm sorry. The definition of microcredit services means A, any one or more of the following services provided by a microcredit institution. No. The proposal is that the words provided by a microcredit institution be deleted. There is no insertion of additional words. Right. So the definition of microcredit service is amended to delete from A, provided by a microcredit institution.
Thank you, AG. So the correction is microcredit service means any one or more of the following services, deleting the 5 words provided by a microcredit institution. Thank you very much.
3 to 7. To 7.
All right. At clause 8, there is an amendment.
Madam Speaker, the amendment is to delete clause 8 as it is worded and insert there in its place the following clause. In making a determination on license approvals or revocations, the supervisor shall consult with the minister on matters relating to the national interest.
Members, there's an amendment to clause 8. We are deleting clause 8 and instead instituting the words, in making a determination on license approvals or revocation, the supervisor shall consult with the minister on matters relating to national interest. Those in favor?
Aye.
Those against? So I therefore put the amendment to clause 8 as clause 8 as amended. Those in favor? Aye. Those against?
I suggest, Madam Speaker, put 9 to 65, clauses 9 to 65.
Madam Speaker, there is an amendment. May I instead respectfully propose that you take parts by parts? And a slight amendment is to be made to clause 48, subclause...
Clause 48.
So, in the interest of time and orderliness, you can do the parts, yes.
Clauses 9 to 47, Madam Speaker. Madam Chairman, clause...
Members, I now put clauses 9 to 47. Those in favor? Aye. Those against? The ayes have it. To clause 48.
Madam Speaker, the proposed amendment is to 48(4)(c) to delete the words after giving the licensee reasonable notice and. So the clause, the subclause would commence subject to subsection 7. Deleting the words after giving the licensee reasonable notice and.
Okay, so delete. The amendment to clause 47 is that 48 is that 48 section 4C. The words after giving the license reasonable notice and be deleted and instead read subject to subsection 7, require a person appointed by the Commission under paragraph B to enter upon any premises where the licensee carries on business of providing microcredit services in order to conduct the investigation. Those in favor? Aye. Those against? The ayes have it. So I put clauses 49, 48 as amended. Those in favor?
Aye.
I now put clauses 49 to 65. Those in favor? Those against. The ayes have it. I now put the first schedule. Those in favor? Those against. I now put the second schedule. Those in favor? Those against. I have it. Ayes have it. Now, as far as the third schedule is.
Yes, Madam Speaker. The third schedule of an amendment to first delete the word "and" at the end of item 15. Number 2, renumber item 16 as item 17. And number 3, insert next after item 15 as amended the following as item 16. And it would read 16, the provision of credit facilities by an employer to an employee or to a person in the full-time service of the employer, semicolon, and.
So the amendment is that in section 15 of the third schedule, we'll delete the word "and." We'll read section 16 and 17. And in 16, we will have the provision of credit facilities by an employer to an employee or to a person in the full-time service of the employer. And, the word "and" is placed here. And then you read 17. So we have 15, we remove the word "and," then we do 16, which will now read the provisions of credit facilities by the employer to and employee to a person in full-time service of the employee, and then insert. 16 is now renumbered to read 17. Are we all together? 16 is now renumbered to read 17 because you have 15, you're deleting the word "and," you're putting in the amendment to 16, and 17 would read any other transaction, person or entity specified by the minister in order in the Gazette. Are we in agreement? Those in favor?
Aye.
The third schedule, the amendments. Those in favor? Aye. I now put the fourth schedule. Those in favor?
Aye.
I now put the ayes have it. I now put the fifth schedule. Yes. Is there? Isn't there a fifth schedule? Yes. Those in favor? Those against? And there is a sixth schedule. I now put the sixth schedule. Those in favor? Those against? The ayes have it. I now put the title and the enacting clause. Those in favor?
Aye.
Those against? The ayes have it. Members? The question is, I do report the bill as having passed committee stage with the amendments. With 6 amendments. 6 amendments. Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, I ask that the bill be read a third time.
Madam Clerk? Those in favor? Those against? Clerk, read the bill.
A bill entitled An Act to License and Regulate Microcredit Institutions that provide financing to individuals and micro, small, and medium-sized enterprises and for connected matters, read a third time and passed.
Madam Speaker, I now rise to ask for a suspension of the standing orders to allow me to deal with the supplementary, Madam Speaker. To refer the supplementary to the PAAC, but you want me to say it formally?
question is, those in favor? Those against? The ayes have it.
No, Madam Speaker. Yeah, no, but I just have to say two things on doing it. But before doing that, Madam Speaker, I just want to again say thanks to all members of the House on both sides who stayed through the debate, and thanks to the opposition for, at the end of the day, supporting the bill and supporting the fact that we, brought it last week and we are passing it this week. I appreciate that, and it's good that we can work together on matters of national importance. Madam Speaker, can I go ahead on the supplementary? Madam Speaker, the COVID-19 pandemic continues to impact the Jamaican economy. After approval of the second supplementary budget in September of 2020, the forecast of the GDP contraction for the fiscal year was revised from a decline of 7.9% to a decline of 11.6%. Different institutions had ranges. Some said 10 to 12 and so forth, but the point estimate that we're using is 11.6. As noted before, for the 7 months to October 2020, revenues were slightly ahead of budget, and I would have spoken to that when I spoke on tabling the amendments to the FAA Act. However, by the end of December, that margin was erased. We had a margin of about $2.5 billion, and you'd have heard me speak to it. That margin was erased, and with great effort by the Revenue Administration team, revenues were on target for the 9 months ending December 2020. So for the 9 months, we're on target. But clearly, you go from having a margin in October that's erased by December. It is clear right? So, Madam Speaker, we cannot evade the lower GDP projections for long, meaning after the second supplementary, the projections were lowered. And the expectation is that the revenues for this quarter will be affected by the prolonged nature of the pandemic. The significant adjustment in the growth rate translates to lower revenue than estimated for the second supplementary estimates, and therefore the need for a downward adjustment of budgeted expenditure as we seek to ensure the maintenance of macroeconomic stability, i.e. not doing anything to jeopardize that. It is within this framework that a third supplementary estimate has been developed and is being tabled today to be referred to the PAAC, whose membership I am grateful to for agreeing to meet this Thursday and to consider the estimates. And membership on both sides of the House. Many of the members live outside of Kingston, and we're very pleased and grateful to them that they'll be coming in. Based on the current forecast for GDP, it is estimated that central government revenue will be $8.6 billion lower than projected for the second supplementary estimates. Given this expectation and taking into account the critical expenditures that are still required, particularly in relation to elements of the Ministry of Health's COVID-19 response, so even though we are seeing that we're projecting revenue will be $8.6 billion lower than in the second supplementary, we still have increased expenses, like from health. So when you put everything together, the third supplementary estimates propose a net reduction in expenditure of $3.5 billion, and that's after providing for an increase in the budget to the Ministry of Health. Now, the reason why we can have a 8.6 revenue decline and a 3.5 expenditure adjustment is that there are many expenditures that we are able to, for example, postponement of the local government election costs $970 million or thereabouts, $950 million, and in the third supplementary, we're doing away with that. And there are other sort of big ticket items like that that we have been able to adjust. This combination of revenue and expenditure generates a primary surplus of 3% of GDP, 0.1% below that of the second supplementary estimate. The 0.1% reduction has been deemed necessary to ensure that the responses that address the resolving COVID-19 pandemic continue to be implemented during the fiscal year, thereby aiding in reducing the timeline required for recovery from the impact of the health pandemic. So at the same time, we have to try and absorb the crisis, but not make the absorption such that we lose the stability that we have. And it's a fine balancing act, but Jamaica has been able to do so balance to a much greater extent than other countries in our region, the Caribbean and Central America, and numbers bear witness to that. Central government expenditure has been revised, therefore, to approximately 850.3 billion, reflecting a net reduction of 3.5 billion below the 853.8 billion provided in the second supplementary estimate. So, Madam Speaker, in the worst crisis in 100 years, we're still spending roughly in the same ballpark as we proposed to spend when we tabled the original budget in March, notwithstanding the fact that revenues are going to be down by nearly $80 billion a year. That is something that, as Jamaicans, we should be proud of. So the reduction of 3.5%, Madam Speaker, has been contained with the non-debt expenditure, and there'll be a reduction of $2 billion in recurrent programs, which we'll outline next week, and $1.5 billion under the capital program, with no adjustments to public debt expenditure. Now, the adjustments on the capital, I want to be very clear, relate to moving some payments for goods bought from overseas which were programmed to be paid in March, at the end of March 2021, just moving those into April. And I give you a big example. We would have made much of the 35 trucks that we bought, and we were to, a payment of $747 million was due on March 31st, 2021. The third supplementary estimate is going to move that payment into next fiscal year, and so the payment will be made in April, and that facilitates the expenditure reduction of which I spoke earlier. The COVID-19 pandemic has significantly curtailed the ability of some ministries, departments, and agencies to complete some of the program activities, including the recruitment of staff and the execution of project activities. The available space, therefore, so in other areas, entities have just not been able to spend, and this happens every year at this time. You go through the budget, areas that they cannot spend. There are only 2 months left in the financial year. The warrants for January are already being issued and signed, so there are only 2 months left. And we go through entities that can't spend, we reallocate. And that available space has either been redirected to other MDAs to meet critical areas of operations, for example, in the Ministry of Health and Wellness and the Police Department, or has been cut from the budget. Other adjustments reflect finalization of subject assignments which took place in September 2020. More details will be provided on the opening of the debate of the third supplementary estimates next week, and of course in the standing finance, but it's just customary to provide a 2-page guide, especially for the media, because the documents in the Yellow Book are difficult to put together in any kind of narrative way. The government remains committed to implementing the required adjustments over the next 3 years to ensure that Jamaica gets back on track to achieving its legislative fiscal targets. Thank you, Madam Speaker. So I ask, Madam Speaker, that formally that the third is approved. Okay, thank you, Madam Speaker.
The question before the House is that the motion be approved. Those in favour? Those against? The ayes have it. Members, before we go on, move forward, there are 2 things. Are all the members of the PAC aware of the meeting of the PAC on Thursday? PAAC on Thursday. Chairman, they are? And with that, I ask for the Parliament's indulgence for suspension for us to go back to the item questions and answers to questions. Those in favour? Aye. Those against?
Madam Speaker, in having the recommittal of the item question and answers to question, we ask that this enable the member from Manchester Northwestern to give notice of 2 questions. Thank you.
Member.
Thank you, Madam Speaker. At the expiration of 21 days, I will ask the Most Honourable Prime Minister the following questions. At the expiration of 21 days, I will ask the Minister of Transport and Mining the following questions. Thank you very much, Madam Speaker.
House Leader.
Madam Speaker, it is not contemplated for us to do any further business today. I therefore ask that the House adjourns to Tuesday, January 26, 2021 at 2 p.m.
The question before the House is that the House to adjourn until next Tuesday, the 25th of January. Those in favor? House is now officially adjourned.
Hello and welcome to another edition of Jamaica Magazine. I'm Adrian Atkinson. Between the pages, a safer and more secure public transport system for the nation as we look back at 2020. That and more as we provide you with the information you need to improve your life. Stay with us. It all begins